Yeah. Well, may I mention item number 28, my lord?
28.
Yes. With the concern other side, my lord, in this matter, GMC has filed an affidavit yesterday. We have to pay for few time, my lord.
Okay,
Your
Mr.
Lordship,
G.
I'm appealing for respondent, Your Lordship. That may be fixed, Your Lordship.
Mr. G.N. Sahola, Learned Senior Counsel appearing for a petition, has submitted that an affidavit on behalf of the respondent GMC has been filed recently and has sought for how much time?
3 weeks time.
3 weeks time to file an affidavit in reply to the said affidavit in opposition filed by the CMC. Your
Appealing for respondent S. Diffusa on behalf of M. Chaudhary, Your Lordship.
Yes. 4, 5,
Mr. S. Dipusa, Learned Counsel for the respondent number 4, 5, and 6 is present. Please the case. Another prayer is allowed. Prayer to file affidavit reply is allowed. Place the case on so and so that.
6 December.
May I please, Lord? My lord, yesterday we have filed a writ petition challenging the delimitation of Kachar district, my lord. My lord, similar matter is fixed on next 6, my lord. That matter may be listed on 6, my lord.
6th.
6th or 5th, my lord. I will verify, my lord. Obliged. Item 28, interim may continue, my lord.
On the interim order, past earlier shall continue till the next date of listing.
May I please, my lord, I have mentioned for listing a matter, my lord, or order, my lord. My lord, service has now already completed, my lord.
Later than you.
May I please, Your Lordship. Your Lordship, I beg to mention one writ petition for withdrawal on 4th, Your Lordship. Thank you.
May I please, Lordship? Lordship, in item number 26, we are filing a affidavit in reply today. Taken the consent of the other side, can it be after a week?
Okay. Who is for the
My
brief?
lord, I appear for the private respondent.
Okay. Mr. M. Das, Learned Counsel for the petitioner has submitted that an affidavit in reply on behalf of the petitioners is going to be filed today.
Okay.
Full stop. And in that view of the matter, he has sought listing of the case after a week.
Lord, the date may be fixed.
Mr. A. Bhatra, Learned Counsel for the respondent number 5 is present. As is the case accordingly after on so and so date.
May I please, my lord, in respect of item number 27, I'm appealing
Yes.
for the petitioner, my lord. I'm praying for an adjournment. I'm going to file a reply, need to file a reply affidavit to the affidavit filed by respondent number 4. I have taken the consent, my lord.
Okay. Mr. T. Chakravorty,
7.
Learned Counsel for the petitioner. Yes, when you are going to file?
I will be filing, my lord. 2 weeks will suffice me.
Okay, Mr. T. Chakravorty, Learned Counsel for the petitioner has paid for and is granted 2 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent number 4. Post of it is submitted that consent has been taken from the Learned Counsel for the respondent number 4 to make the prayer. Post of MS as Borua, Learned Junior Government Bograsa, Border State Respondents, and MSG Hazarika, Learned Standing Counsel Revenue Department.
Also,
are
there is
in
an interim
attendance.
order that may
The
kindly-
interim order passed earlier shall continue till the next day of listing.
I'm obliged.
May I please, my lord? My lord, I beg to mention item number 13, my lord.
Item number 13.
1 3 minutes.
Okay, Mr.
A.K. Gupta, my lord.
A.K. Gupta. The counsel for the petition has paid for an adjournment. It is submitted. You have informed.
Yes, my lord, I have informed.
It is submitted by Mr. Gupta that the learned counsel for the respondents are duly informed. Post to place the case as prayed for after
In the next week, any date, my lord.
a week. After a week. Item number 13.
Not, I have one another prayer for listing of a writ petition, my lord, for motion, my lord. What happened, my lord? All the bank accounts of the petitioner, including the cash credit account and overdraft account of the petitioner, is freezed, my lord.
Motion
Motion, my lord.
next week.
If possible, today, if possible, my lord.
Today this court is rising at 1 o'clock.
Then, my lord, on Tuesday, my lord.
Not Tuesday, Wednesday.
Please, Your Lordship. Lordship, with respect to item number 18, we have filed an additional affidavit today, my lord. That may be recalled for, my lord.
Yes.
May I be lordship? I beg to mention two cases for withdrawal. Any that?
Okay.
I beg to mention a listing, my lord, no order column, my lord. It was listed, my lord, 3/12/2034, my lord. Thereafter, it was not listed, my lord.
Okay, next week, huh?
Yeah.
Orders.
Please, your lordship. I beg to mention item number 3, lordship.
3.
Lordship, a new set of counsel has been engaged by the petitioner, lordship. May it come after 6, lordship. After 6, lordship.
611.
Yes, lordship.
Yes, aviator. Repetition is maintainable.
I have my doubts, Lord, because it's a principle.
Principal Court of Civil Jurisdiction. Think it over. We'll decide the maintainability also. Okay, Mr. S.J. Sharma, Land Counsel for the petition has submitted that the petition has engaged a new set of counsel to represent post of Mr. B.D. Dekar, Land Counsel for the Caveator is present.
I'm for respondable.
And Mr.
NHA. R. Boro, Lordship.
R. Boro, Land Standing Counsel. NHAI
NHA on behalf of C. Boro.
are present. List the case as prayed for in the next week. In the week commencing from 11th November. On a day, in the week commencing from 11th November.
May I please, your lordship. Also, available listing for withdrawal.
Withdraw.
Bless.
Also, item number 1.
So in this matter, I was directed to take instructions here, lordship. I have communicated that day itself. I have received any instruction yet, your lordship.
We tried to expedite anyway. Heard Mr. S.I. Land Counsel for the petition. This writ petition
Contempt petition.
this contempt petition is preferred alleging non-compliance of the direction contained in an order passed in an order dated 18/3/2024 in a writ petition WPC number 1539/2024. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents by registered post with AD within 3 working days.
So,
Bless you.
Item number 2.
May I please, your lordship. Lordship, in this case, lordship, we have challenged the order in original. Lordship, the order in original we have challenged because, lordship, this order is barred by limitation. Lordship, may kindly see first the SOCOS notice. Lordship, even the SOCOS notice is barred by limitation. Page 92 is the SOCOS notice, which has been issued to me. Lordship, this matter is relating to Service Tax, Finance Act 1994 and pertaining to the assessment year 2016-17. So, lordship, at page 92, if your lordship will see that for the assessment year 2016-17, my SOCOS notice has been given to me on 11/4/2022, which is after 5 years of the end of the financial year, lordship. Thereafter, lordship, may kindly see that even though the SOCOS notice was given on 11/4/2022, the lordship order in original, which is finally passed, which is at page 115.
Yes.
Lordship, that has been passed on 24/4/2024. Lordship, the date your lordship will find at the second line up above. Order in original number is there, thereafter the date of the order is there. Lordship, 24/4/2024. Lordship, these are the dates I wanted to point out before your lordship. This has been passed after more than 1 year, lordship. That is 2 years of the lordship giving of the SOCOS notice. Lordship, what the provisions of law says. Lordship, may kindly, I may be permitted to produce the Finance Act 1994 in this regard.
এখন দিলে হ'ব, এখন দিলে হ'ব। Yes,
If your lordship will come to page 16, which is section 73 of the Finance Act 1994.
Mhm.
Lordship, section 73 says, Lordship, number 73(1) says, where any service tax has not been paid, levied or paid, or has been short levied or short paid or erroneously refunded, Central Excise Officer may, within 30 months from the relevant date, serve notice. Lordship, this notice I'm talking about the so-called notice which has been issued. 30 months is a lordship, the statutory period, but this can be extended to 5 years. Lordship may kindly.
What is the relevant date explained?
Lordship, relevant date, I will lordship come to provide, lordship may kindly see proviso also. Because lordship, we have to see that they have extended to up to 5 years. Provided that where any service tax has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reason of fraud, collusion. These are the 5 factors. Then lordship, by the person chargeable with service tax, this provision of the subsection shall have effect as if for 30 months, the word 5 years has been substituted. So lordship, 5 years. Lordship, thereafter, lordship will come to the relevant, the definition of the relevant date, which is there in the section itself. Subsection 6. Subsection 6, which is at page 80.
Hmm.
For the purpose of this section, relevant date means, in the case of taxable service in respect of which service tax has been not been paid, levied or paid, or has been short levied or short paid, where under this rules made under this chapter, a periodical return showing particulars of service tax paid during the period to which the said return relates is to be filed by NSSC, the date on which such sum is filed. Where no periodic return as aforesaid is filed, the last date on which such return is to be filed under the said rules. In any other case, the date on which service tax is to be paid under this chapter or the rules made thereunder. Lordship, since I was not liable to pay service tax, lordship, so I have not filed any return in this respect. So I will fall under 6, lordship, subclause 6B, where no periodical return is filed. The last date in which such return is to be filed in the said rules. So lordship, if we consider this,
What will be the last date?
lordship, then lordship, in that case, lordship, then the so-called notice will be, because they have invoked the extended period of limitation.
No, otherwise, if it is 30 months, what is the last date?
Then lordship, it is done barred by limitation, because it is to be filed within 45 days. 45 days from the end of the financial year. That will be lordship May 15th. By May 15th, that has to be filed. Lordship, but my main case is lordship, the order lordship, from the so-called notice to the date of the passing of the order. Lordship, that has to be passed within a period of 1 year. Not 2 years. They have passed within a period of 2 years. Lordship, for that, lordship may kindly see clause 4B of the section 73, which is at page 18, 4B.
Hmm.
Lordship, the Central Excise Officer shall determine the amount of service tax due under subsection 2. Clause A says within 6 months from the date of notice, where it is possible to do so in respect of cases falling under subsection 1. Where within 1 year from the date of notice, where it is possible to do so in respect of cases falling under the provision subsection 1 or to the provisos or 2 of section 4A. So lordship, the time limit for passing the final order is lordship 1 year. In fact, lordship, and they have given the so-called notice in the year 2022 and passed the lordship order in order in the year 2024. Lordship, in this respect, I have filed another writ petition exactly on the same issue. Lordship, may kindly see there is an order which has been passed. The case, lordship. Lordship, may kindly see paragraph 5 of the order. The petitioner submits that the learned counsel for the petitioner submits that the period in question is the financial year 2015-16, and in terms of provision of the act, same ought to have been completed within a period of lordship, it will be 30 months, not days. 30 months. However, invoking the provision of section 73, period has been extended beyond 5 years. Although there is no suppression or willful default by the petitioner in disclosing or payment of service tax. However, notwithstanding the said provision having been invoked, So cause notice was issued on so and so date, and ordinarily the order is required to be passed within 1 year from the date of service of so cause notice. However, the impugned order was issued on 27/3/2024, which is more than 1 year from the date of issuance of so cause notice. As such, it is submitted that the same is clear violation of the mandate of the provisions of the Act.
No, so for section, subsection 1
Yes, your lordship.
of section 73.
73.
If 30 months is counted, it is 2.5 years
Yes, yes.
from the relevant date. But by the proviso, it can be extended up to 5
Right.
years.
They have,
Now, what is the relevant date in your case?
lordship, my relevant date will be May 15, 45
May
days.
15.
Yes, your lordship.
So then, if suppose that invocation of proviso is permissible,
But if permissible, lordship,
suppose,
suppose.
then this notice is within
In that case,
5
lordship,
years.
it will be within the limitation.
But so far as mandate contained in subsection 4,
Or B.
that is what you said, 4B,
Yes, your lordship.
1 year from the date of notice.
Yes, your lordship. That has not been fulfilled. And lordship, in the lordship, if the matter is taken up for final hearing, I will be harping on that, whether the extended period of limitation is also.
That is a ground to be considered after hearing both sides.
Yes, your
After hearing both sides, that is not a ground only hearing
Yes, your
ex
lordship.
parte the petitioner,
That is why. lordship,
right? So for prima facie, it is 4B as on date.
Yes, your lordship. Lordship,
Yes.
if your lordship, in this case only, lordship, even though it is not, in this case only. lordship,
Why it is not proper for the petitioner to prefer an appeal?
Lordship, because this is barred by limitations. So far as barred by limitation cases are there, well, lordship, this is invocable, Article 226 is invocable.
But,
And lordship,
Supreme Court in some cases said if it is barred by limitation, the appeal, then writ petition is not to be entertained.
lordship, so far as the appellate authorities.
I don't know the name of the judgment, but Honorable Justice Khanwilkar in one case,
I will
if it is
not-
barred by limitation, then that cannot be overcome by filing a writ petition beyond the period of limitation.
Beyond the period of limitation, I have filed within the period of limitation, lordship. Even immediately as the order was passed, I filed it, the lordship, the. case-
When did it, when was the order passed?
The order was passed 24/4/2024.
24/4. So what is the period of limitation mentioned here?
It's 3 months.
In the order itself? I
Lordship,
think it is, in the order itself, it is mentioned otherwise.
lordship, normally it is,
60 days.
lordship, as per section 85, it is.
No, you come to the impugned order. Normally, it is the period of limitation mentioned there. It is
Section
already prepared format.
Lordship, but
Deeming itself agreed by this order, may appeal against the so and so within 60 days.
thereafter, lordship, the extent
So when did you file?
was filed in the month of July, lordship, that can be, lordship,
26. That is beyond 3 months.
beyond 3 months, but lordship, that can be extended up to, lordship, this 85, under section 85. so
60 days can be extended up to 1 day.
That 60 days can be extended. Let me kindly, can be extended for 3 months, at one place it is written 3 months.
What is the appellate provision?
Section 85 in the same. 3 says 3 months and 3A says 1 month.
85.
85 subclause 3.
Adjudicator who is subordinate to the so and so may appeal. Prescribed from subsection 3.
3 subclause proviso, lordship, provided that the.
Shall be presented.
If he is satisfied that the appeal was prevented by sufficient cause from presenting the appeal within the state period of 3 months, allow it to be presented within a further period of 3 months.
Presented 2 months. No, it will be subsection 3A.
3A,
An appeal shall be presented within 2 months from the date of receipt of the decision made on and after Finance Bill 2012. So this
This is-
provision is applicable.
3A,
Then it is 2 months.
2 months
And
and
proviso,
1 month. lordship.
within a period,
1 month from receipt of the order, Lordship.
further period of 1 month.
Receipt of receipt of. the order.
If it is satisfied that the applicant was prevented by sufficient or present within the period of so and so, allow it to be presented. So 3+1,
3+1.
but still it is beyond 3+1.
Receipt of the order, Lordship.
You must be aware of that decision, MS Havelia.
Lordship, the date of the receipt is counted because Lordship, that has to be communicated to me by way of Lordship, by way of mail or.
When did you receive?
Lordship, now that is a question, Lordship, I did
Hmm.
not go through. That is a question I have to see, Lordship. When did I receive this? But Lordship.
Okay, for that
normally-
timing, yes, Mr. Gogoi.
Sir, our stand is, we have already mentioned in paragraph number page, your lordship. We have already filed a executing authority, the stand which have been placed before this honorable court, they have already been placed before the executing authority. That is a one page, one.
No question raised in this. We are not going into factual dispute at this stage. Prima facie, it is 73 subsection 1. And secondly, subsection 4B, 1 year. That is the ground raised. So because of violation of 4B, the order in original is also non-in law. That is what
Yes.
main submission,
Sure.
without going into the other aspects. So this aspect, otherwise there is a provision for appeal. There is no doubt about it. Now so far 73 proviso is concerned, that is a matter of discussion, not at this stage. But on the other hand, it appears prima facie that it is beyond, this writ petition is filed beyond the period of limitation and extended period of limitation, prima facie, subject to satisfaction. And law is also settled that if a writ petition is filed when there is a provision for appeal and writ petition is filed beyond the period of limitation, then this is not to be entertained and to give quietus to the litigation.
So far as Lordship.
This is not the end, otherwise no end will be in sight.
Lordship, but so far as Lordship, the.
I am not remembering that, but I can remember that.
So far,
But that is in the context of other previous decisions also.
Arbitration case, not in respect of Lordship's final.
No, tax, yes, tax cases, tax revenue cases, specifically to revenue cases, not arbitration. So we remember both to yes, no coercive action. Yes, Mr. Kyle, he is smiling and nodding. Yes. Okay, okay. Heard. MS. Okay, prima facie 4B, you come up with other, please. And satisfy me that it is beyond
I will.
period of appeal and within period of appeal plus extended period of limitation. Heard. MS and Havelia, learned. Counsel for the petitioner, Dr. B.N. Gogoi, learned standing counsel. GST. For all the respondents,
Lordship.
full stop. The petitioner has submitted that he carried out his business as a works contractor and works contract services and has claimed that works contract services were exempted under the mega exemption notification issued by the respondent authorities from payment of service tax under the Finance Act 1994. Full stop. Petitioner has submitted that despite being exempted, the petitioner was served. Page
Lordship, the notice is 92.
92 was served with a demand cum show cause notice dated 11/4/2022. for the financial year 2016-17 purportedly under subsection 1 of section 73 of the Finance Act 1994 with the contention that the petitioner failed to discharge service tax liabilities to the tune of rupees 26,57,349.90, page 92. Under section 66B, 67, 68, and 70 of the Finance Act, read with the applicable rules. Did you submit any reply?
So far as,
In response to the said demand comes show cause notice, the petitioner submitted his reply on 17/11/2023. Full stop. Thereafter, the adjudicating authority has passed an order in original on 24/4/2024. Whereby, what is the liability? Where is it?
same as, has been.
Executing authorities.
Whereby the adjudicating authority has confirmed the demand of service tax amounting to rupees 26,57,349.90 for the period FY 2016-2017 under section 73 of the Finance Act. Full stop. MS Hawilia, Learned Counsel for the petitioner has submitted that subsection 1 of section 73 of the Finance Act has provided for a demand comes show cause notice within 30 months from the relevant date and within 5 years under the proviso in case of certain particular situations. Full stop. MS Haveli has further contended that subsection 4B, capital B of section 73 has prescribed that the Central Excise Officer is under obligation to determine the amount of service tax due. 4B within bracket small b,
Not-
right?
not-
Within 1 year from the date of notice. Post up. It is the contention of MS Hawilia that whereas when the demand cap show cause notice was issued on 11/4/2024, the order in original ought to have been passed within a period of 1 year therefrom. Post up. But in the case in hand, the order in original was passed on 24/4/2024, which was beyond the time period permissible under the law, and as such, the order in original suffers from illegality. Full stop. As Mr. Dr. Gogoi, Learned Counsel for the petitioner, has submitted that the order in original itself has mentioned that the petitioner could have preferred an appeal before the appropriate authority within a period of 2 months or 60 days.
60 days.
within the prescribed period of limitation or within the extended period of limitation, post of, but the instant repetition is preferred without preferring any appeal, and that too beyond the period of limitation plus extended period of limitation for preparing such appeal. The matter would require consideration, issue notice, returnable in so and so. Insofar as the contention regarding non-compliance of subsection 4B, small b of section 73 is concerned, it appears prima facie that the order in original was passed beyond a period of 1 year from the date of the demand cum show cause notice issued on
11/4/2022.
in such view of the matter, the respondent authorities shall not take any coercive action in terms of the order in original dated 24/4/2024 till the returnable date. Issue notice extra copies within 2 working days.
One thing I wanted to point out, in the proviso, in this subsection B, it is written where 1 year from the date of notice, where it is possible to do so. But it has this, where it is possible to do so has been interpreted by various high courts, saying that it's always possible to do. You have to show extraordinary circumstances like COVID that you were not able to do that.
So you reserve that argument for the later date. Prima facie, we are convinced that not in the period of 1 year.
My answer is already been given here, Lordship, in our scan.
Huh?
If it will be validated permission meant to me, I will highlight it here also.
Okay.
Otherwise,
File your reply.
Lordship. Item 4.
Mr. Sen, Mr. Sutia, because we are rising, I was not aware that I'll be rising early. So can it be on Tuesday to pass a order? Otherwise, some time will be consumed. And you'll be with the appropriate remedy. Don't worry about that. BK Sen, petitioner, C. Sutia, standing counsel KAC, are present, lays the case on Tuesday.
Item 5.
Yeah, I take it upon deliver. Yes, Mr. Mojumdar,
Lordship,
standing counsel agriculture. Have you served?
yes, sir. Yes,
Served?
yes, Lordship, I have served the copy.
Yes.
And
Where is
it's also reflected in the cause list. May I submit, Lordship?
that? Yes.
Lordship already heard the matter, just to refresh the memory in brief. Lordship, this petitioner organization is a registered self-help group, which is registered by the competent authority of the Agriculture Department. And all the members of the SHG are belong to the farmer family. And in this regard, the certificate of farmer is also issued by the competent authority.
No, there is no difficulty in issuing a notice, but you are also praying for an interim order.
Lordship, this till the next day, no further decision.
We'll hear them because it is regarding not businessmen. This is cultivators.
I am also cultivator.
You are also cultivator. That does not mean that other cultivators should be deprived. Had it been big businessmen, it is a different thing. Am I clear?
But in that
Where is
case,
it, Mr. Agriculture? Find out, Mr. Agriculture. Call somebody. We'll take up. But on the issue, what will be the effect? We'll hear also.
Item number 6.
Yes.
May it please your lordship, as per your last order, that is 25/10/2024,
Copy
We
served.
we are, due to some unavoidable circumstances, we are not able to serve the copy on 28th, that is Monday.
B. Gugoi.
Yes, your lordship.
He is omnipresent.
he said that copy has not been served on time.
Ah.
I just talked to him. He was in court number 1.
Otherwise, B. Gugoi is available everywhere, in every court. Why you could not serve?
Your lordship, due to some unavoidable circumstances,
Okay.
we are not able to serve the copy, so we may be.
Serve him today. We'll
Yes,
take
sir.
up on Monday, not Wednesday, or Monday, or not Monday, Wednesday. Wednesday?
On next Wednesday I will be out of work.
Okay. Friday or Friday? Friday to let's have it. 11. Miss Anan Hussain, Learned Counsel for the petition has submitted that despite approach, a copy of the writ petition could not be served to Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department, Assam. Post of Mr. S.C. Kyle, Learned Standing Counsel, GST, is in attendance. Full stop. Name is shown.
My name is Sanjay.
His name? Item number?
6.
Copy of the petition will be served to us.
Okay, you are having a copy. Okay. Mr. H. Borua, Learned Counsel, representing Mr. B. Gogoi. Standing Counsel, Finance and Taxation Department has appeared. Stop. Mr. M.S. Hussain, Learned Counsel for Petitioner, has submitted that she will serve a copy to Mr. Borua during the course of the day. Post of as sought for by the Learned Counsel for the parties, list the case on 11/11
Highly
in a motion column.
7.
Right, it is a very small matter regarding the person is approaching the SDM for under CRPC 130 proceeding. The proceeding is initiated and the defined date has been done. In finally on 11/6/18, that the inspection is taken place and thereafter nothing has been done, no date has been given. Therefore, only my prayer is that the matter should be that proceeding should be expeditiously conclude the proceeding. Otherwise, the other remedy I could not avail the other remedies.
Fighting between two neighbors. She is going beyond the boundary. That is disturbing you. And what is the rule? Otherwise, this page 45, that is a proceeding.
Yes, Lordship will find
That is a proceeding. Page 45.
45 onward. Yes.
Madam, can you, otherwise we have no role here.
I wanted all state, Lordship will permit to state.
No, I can ask for instruction about the stage of the
Yes, I know.
proceeding. But otherwise, we should not direct also.
Yes. No, Lordship cannot direct.
We are not going to issue notice, just have an Ms. Borua to obtain an instruction about the present status of the proceeding, whether it is concluded or not concluded.
Yes.
So once a proceeding is done, it should be brought to a logical conclusion. This way or that way, right? Ms. Borua, you please take instruction from which place?
Bukakhat.
Bukakhat. Who is the authority? Who is?
SDM.
Huh?
SDM Bukakhat.
Okay. Heard Mr. P.P. Borua, Learned Counsel for the petitioner, and M.S. S. Borua, Learned Junior Government Advocate. Assam, G. Hazarika, Revenue 1. S. Borua, Junior Government Advocate. For the response number 2, 3, and 4. Full stop. The petitioner is aggrieved by inordinate delay in bringing the proceeding on the part. You're not making him a party. 3. Subdivisional commissioner.
Yes.
SDO, subdivisional officer, or
Subdivision magistrate.
it should be magistrate.
Magistrate. Page 36. Magistrate.
Subdivisional commissioner.
Subdivisional magistrate actually.
Actually, they will come to subdivision magistrate, page 36.
When he drop this kind of proceeding, he is magistrate.
Magistrate. He is acting as a magistrate.
কি করলো? Proceedings of
CRPC 17.
CRPC case number 28
Yes.
of 2017, drawn up under section 133, Code of Criminal Procedure 1973, to a logical conclusion despite long pendency of 7 years. Also, the said proceeding are between the petitioner and the respondent number 10. Full stop. In the said proceeding, the petitioner is the petitioner stroke first party and respondent number 10 is the second party. Full stop. MS Borua, learned junior government advocate, is to obtain instruction as regards the status of the proceedings, present status of the proceedings of CRPC case number 28/2017, and the region, present status of the so-and-so, by the next date of listing, Mr. Borua and counsel for the petitioner shall furnish a copy of the writ petition along with an extract to MS Borua during the course of the day. List the case on 22.
For listing the name of estate.
The name of and standing counsel, Revenue Department, will be reflected in the respondent side in the process. You furnish a copy.
Typing method, item number 5.
Yes.
Lawsuit, in this case, lawsuit earlier occasion, they have not served copy to the aggressor standing counsel.
No,
Now,
that is why I have asked
yes,
him to serve a copy to you
yes, okay.
and to reflect the name. Yes.
It was submitted to Mr. B. Soduri. Today he has not come because his mother is seriously ill. Lawsuit, so copy went with him. I have to go.
Oh,
to
yeah,
the
Mr.
second.
Mazumdar is also asking for
Yes.
an interim prayer. That is why.
That interim prayer, it should be difficult at this stage, lawsuit. We have to take an instruction first. I have gone through it, lawsuit.
You have gone through it.
Yes,
Okay, it is available with you.
I have done the second copy. Of the
Okay, okay, okay.
Lordship, one issue is there that the guideline, Lordship, is if you peruse the guideline. The guideline says that the marginal farmer are entitled to get the benefit. And the select list shows that the person. has-
You are self-help group.
Yes, Lordship.
Okay. To what kind of benefit you are entitled under the scheme? Which page?
That the
I have
benefit,
forgotten. That is why.
that under the scheme, the benefit is that central government funded by the central government and the state agriculture department is the nodal agency and they are providing some agricultural equipments to the farmer at the subsidized rate, such as the power tiller and all other equipments.
This is submission on agriculture mechanization.
Mechanization.
This is the scheme.
This is a scheme, Lord.
Now, where is that selection procedure?
Lord, you will find page 12, start, and the relevant portion is page 21.
Page 21. DLG is responsible for carrying forward the objective of the mission for project formulation, implementation, monitoring. The office of the census shall be the district agency. Identify beneficiaries to avail the benefit of so-and-so in transparent time. Identify entrepreneurs to establish custom hiring center. You want what? Custom hiring center?
Lordship, that, pardon,
Huh?
I am a self-help group and the object of the.
No, if I have remembered correctly, farmers are entitled for different benefits.
Yes,
And a self-help group or that groups
or the
are entitled for different benefits.
the same benefit, including farmer, it says that.
Let us see, page 21.
Identify beneficiaries, farmers, self-help groups, SHGs, user groups, cooperative societies, farmer producer organizations, and entrepreneurs. That is all the.
Then identify entrepreneurs, self-help groups to establish custom hiring center. Now, what is your case about?
My case is that in the first objective of the scheme is to provide the benefit to the area where the implementation of the agricultural mechanization is very less and the marginal holding farmers. And my case is that the benefit is given
No,
to some farmers who are not,
no, this is one is submission on agricultural mechanization, right?
Lordship.
You have to, and what is Pradhan Mantri Kisan Samman Nidhi scheme?
No, that is not directly connected with that scheme.
Then why you have annexed?
I have an
Why you are confusing the code?
Lordship, I'm
Huh?
that the farmer, definition of farmer is there. That is why I have annexed,
Only for that purpose.
only for that purpose. I'm not.
Registration of Agriculture Service Group. Okay. So, you are a self-help group.
I am self-help group.
Okay.
Lordship will find a list of beneficiaries in number 40.
Now, what is the ground of challenge?
That a benefit is given to a person who is running a self-help group, that he cannot be termed as a marginalized farmer because his property details I have annexed and the annex at G.
List of the page 40?
Page 41, entry number
41,
41, entry number 46.
46, PC,
This is
Fitia,
SG,
AZ. AZ means
Agricultural Service Group. It is
agriculture,
registered under the SHG.
SAG.
SHG. The beneficiary is the Odesh Kumar Singh,
Odesh Kumar Singh,
and the said beneficiary is
Nutan Nagar village. So this is block wise or village wise benefit?
LSE wise.
LSE wise. Okay.
And
Why he is not eligible?
Lordship may come to the page number 43 and exact G. This is the affidavit that I have got from the official website of the Election Commission of India, as the beneficiary is the candidate of a particular political party and he has contested election twice. Assembly election, and his property is more than 1.5 crore, and he is the income tax payer also. So
Where is that? Where from it is
Pleadings,
reflected?
guys, I don't think that pleading he has taken all these points.
Huh?
In the pleadings, I don't think he has taken all these points.
but if you peruse the page 43, his property details is there, and he is also.
But you have to make a statement on oath also.
Yes.
Where is that?
Yes, I have.
Okay.
Not they were made parties, Lordship. Because
The
he has
party is
specific allegations against those particular.
No, Lordship, yes, I will address the issue party. That he is one of the beneficiary. I am not seeking any relief from him. And second is that there are more.
Then you cannot say then anything more. If you are not seeking allegation, you are making not ousting him, seeking ouster of him.
No, I am not Lordship. That is why I am telling that I may be given 2 minutes to satisfy the court. That I have annexed the affidavit as a reference.
No,
That there are
Mr.
some
Ojumdar, I had said at the very beginning, right, that we will not have any difficulty in issuing notice. But we, for the purpose of stalling
The whole
by way of an interim order, somebody has to be there.
Lordship,
Otherwise, the whole hog we are not going to do it.
Lordship, the
And
another-
you have brought an allegation that an income tax assessee is not entitled for the benefit. And you have made an amendment to that effect also. Paragraph 9, I have seen that his declared asset is 1 crore so and so. But he is not there. Why should I
Yes, I'm coming.
Why should I?
Yes, Lordship is right, but my understanding, Lordship, it may be accepted or rejected is up to the court. There are 400 more beneficiaries. And if the court is satisfied and intervened, then every beneficiary shall be affected. And it is not possible to make the 400 main party. in
That
my
is what-
petition.
But
I
whatever,
have given the just reference that there is some violation.
will
it
issue
is-
notice at this stage.
Lordship, then my
Lordship,
humble.
allowed me to take instruction in this case.
Lordship, my humble submission is that it may come up on the motion column again. In the meantime, I'll file a amended.
No, you cannot go on doing that.
Then I may be allowed to withdraw and file a fresh.
That he has, yeah.
Then what is that?
Because
from the-
you have been
No, we don't
granted
need
time
anything.
earlier also. But still you are not doing it. Making some allegation against somebody. We have to do
Yes,
it.
sir, I may be allowed to withdraw and with the liberty.
Whatever illegalities were there in selection of beneficiaries, they have to be made parties.
Yes.
And my understanding was something, it may be wrong, I may be on the wrong footing. That is why my petitioner shall not.
Heard,
should not
Mr.
suffer.
Mr. Abjad Majumdar, learned counsel for the petitioner has submitted that the petitioner may be allowed to withdraw the petition, come out with the liberty to file a fresh post of Mr. Assembly still standing counsel agriculture department who is in attendance, has submitted that he has no objection to the prayer for withdrawal with liberty. So in view of the above submission made by Mr. Majumdar, learned counsel for the petition, this writ petition stands dismissed on withdrawal, with the liberty as prayed for.
Obliged.
Yes,
May-
Mr.
may-
Bolwa, for what?
Lordship, petitioners are the cooperative society in the district of Tinsukia, my lord. And they lifting food gains from the FCI go down and distribute to the beneficiaries for the fair price stock, my lord.
That practice has been stopped, I think.
My lord.
That practice has been stopped.
Stop, my lord. This is the period for 2020, my lord.
20
To outstanding payment regarding outstanding payment,
outstanding payment.
My lord.
Okay, well, issue notice
My-
at this stage.
my lord.
Well, issue notice. Yes, MS Borua, you appear for whom? All response. Heard, Mr. R. Borua, learned counsel for the petitioner. Petitioners, who are GPSS societies involved in lifting food grains from FCI godows and to transport it to the respective fair price shops. Shop dealers under the National Food Security Act, 2013 during the period from
This is the outstanding for the period April 2020 to November 2020.
during the period from inter alia, during the period from April, 2020 to November 2020, and for the purpose of the said service, the petitioner societies are entitled to a commission per quintal
per quintal.
as full stop. As despite submitting representation stroke claims before the respondent authorities, the commission amounts to the petitioner societies are not disbursed till date. The petitioner societies have approached this court by the present writ petition. Issue notice returnable in 4 weeks as MS Borua learned junior government advocate. Sum has appeared and accepted notice on behalf of all the respondents. Issuance of formal notice to the state respondents and dispensed with. The learned counsel for the petitioner shall have shall furnish requisite number of extra copies of the writ petition along with annexure to MS Borua within 3 working days from today. Release the case after 4 weeks. Deeply.
Item 9.
Okay, please, your lordship. Lordship, in this case, lordship, what has happened, lordship, I'll just state some brief facts. And lordship, I just wanted to say that whether they are allowing me to pass a similar order in this case. Lordship, what has happened is that, lordship, in this case, a so-called notice was issued to me by some other officer. He is the person who has heard me, but the final order has been passed by some other officer. My second question is that there are 2 assessment years. They have passed a single order, means demand order has been passed for 22-23, but 21-22 amount has also been taken into account. 2 years.
That was not part of the notice.
That was not, even though it was part of notice, but the notice did not mention that it is going to be 21-22 and 22-23, 2 different orders. Lordship, if I am
Where is that notice?
Lordship, the notice is Lordship, the notice is at page 47. Lordship, my main contention, Lordship, this can be discernible. Lordship, may kindly see at page 48, there is financial at 21-22. And you may also see financial at 22-23. So for 2 years, they have sent notice. And Lordship, they have passed a single order at page 9/4/2024, which shows April 22, March 2023. Lordship, but
No, which page?
Page 51. The demand order which has been passed.
51.
This is April 22 to March 2023.
No, 51 is summary.
Oh, sorry, I'm so sorry, Lordship. This is GRC 1, which has been issued to me. Lordship, 54.
54.
Order. Lordship,
Yes.
amount we calculate, we see that even though it is written for 22-23, they have taken the figure of 21-22 also into account. But Lordship, I don't think so, Lordship. After I went through the case yesterday night, this honorable court will not be able to verify this amount whether 21-22, it has to go into the thing. Lordship, that is why, Lordship, I have requested them that these questions, but Lordship, these questions which I have raised in this petition, the appellate authority cannot, Lordship, go into this question. Lordship, in a similar case.
Which question? Which question? I don't know. Which are the questions you are raising?
Questions which I am raising, Lordship.
Ah.
First is that the person who has issued me the so-called notice is the person who should pass the final order. Because
Was there any personal hearing?
Lordship, the personal hearing was given to me, but Lordship, I took a time, but that person who has provided me the opportunity of hearing and before whom, suppose in Lordship, it happens sometimes in customs also, in GST also, that if I am issuing the notice.
That is not an absolute principle that the person who hears,
Yes.
must decide. In certain situation, this is not inflexible. But question that that is why I have asked the specific question whether personal hearing was afforded to you.
I was afforded to me.
And did you appear?
I took time.
You took time. It did not appear.
No, that is why, Lordship, I
Otherwise, it would have been the principle would have been clearly applicable. That
Yes.
person who heard
should
decide or must decide.
decide.
But here is not a question.
Because Lordship,
Now, which authority passed the order?
the assistant commissioner, the junior passed the order, assistant commissioner, deputy commissioner issued me the notice, so-called notice, and assistant commissioner. Has
Yes, Mr. Borua. That is one. And second?
Second is that, Lordship, for one, if you are passing the order for assessment year 22 and 23, you can't take the figure of 21-22 into account. For 21-22, pass a different demand order, no problem. 22-23, you pass a different demand order. But you can't mix both the figure in one 22-23 and pass order for 22-23. Taking into account
The so-called notice was issued for 21-22 and 22-23. Is there any bar?
Yes, Your Lordship. If Lordship, supposing I spend 10 rupees for 21-22, 20 rupees for 22-23. If you want to tax me, for 21-22, you tax 10 rupees for 21-22. For 22-23, you tax 22-23. But 30 rupees you can't tax for 22, 23 because that 30 rupees total, you can't make total 30 rupees.
That is what you are saying. Now, otherwise, so-called notice, they have shown page 48, different tables,
They can, Lordship, but they,
different tables, but otherwise 21, 22 is zero.
even though zero, but because ITC is zero.
Okay.
IT is zero.
Yes, Mr. Borua?
Notice may be issue registration.
Huh?
I don't notice maybe issue
Lordship, I
registration.
don't think so notice is required because I am saying that it may be remanded back to the officer and Lordship, I may be allowed to permit to file appeal and I may be permitted to take all these questions which I am raising in this writ petition. Secondly, Lordship, the second thing which I am saying is that my account is freeze, Lordship. My account is freeze, I cannot pay 10%. So, Lordship, this honorable court has already dealt with this situation that if my account is freezed, either you don't take 10% because that amounts to security. You are getting the entire amount as security.
Okay, let Mr. Gogoi Wednesday then let him,
Lordship,
you
this is-
apprise Mr. Gogoi
The-
about the submissions made by MS Havelia. Huh?
Taking consideration in the next day, my lord.
this
You
order-
apprise Mr. Gogoi about the contentions raised by MS Havelia, whether it is acceptable to him or not.
My lord.
Okay, heard Ms. S. Havelia and Havelia Learned Counsel for the petitioners and Mr. H. Borua Learned Counsel representing Mr. B. Gogoi. Standing Counsel, Finance and Taxation Department has submitted that the case be listed on Wednesday again in order to for hearing in order to enable Mr. Gogoi to make his appearance. Please the
Take
case
instruction.
Huh?
And take instruction on this.
Wednesday. You hand over to Mr. Gogoi.
Lordship,
Please the case on swings.
9 and 10 are same. Lordship.
9 and 10 are same. Okay. Same thing, huh?
Much obliged.
Highly obliged, my lord.
Item 11. May I please, your lordship, here in this case, my lord, installation of mobile tower, my lord, Airtel mobile tower, my lord.
Yes.
They have violated the guidelines, my lord. That is the
What guideline?
guideline, my lord. I have annexed it, page 34, my lord. And relevant is page 36.
36.
Yes, my lord. 34 starts from 34 and relevant is page 36.
You're not annexing entire thing. There is a provision for appeal also. Mister? Huh?
But I have also submitted.
You're not annexing the entire thing.
I have also approached before
Bring
the-
the entire guidelines, mister, because we have disposed of all this. Earlier, there is a committee. Is it not? To prefer appeal, headed by district commissioner and all other experts.
I have already.
They will deal with all these issues.
but
Why should we deal? That petitioner
Everything, my lord.
and neighbors, there are disturbances. They will do field inspection, they will do everything. There is a committee who have passed many judgments.
In this respect, my lord, I just.
There is an operational guidelines,
My
mister.
lord,
You have not annexed the whole document, perhaps.
it will be a much larger, my lord.
But don't try to maintain a writ petition everywhere when there is an efficacious remedy. And they are best positioned to deal with the issue. Whether there was permission, not, they have power to stop.
I have already approached before them, my lord. We are not hard, my lord.
You know, bring that, we'll pass the direction or observation.
My-
Asani. Oh, it is there.
Page
In fact, my
30
lord, page 38, representation was filed before the secretary, my lord.
My lord,
Open
page
side
32
secretary,
also, page 30. Page 30. Subdivision.
SDO signature.
Now it's a for district commissioner.
There is a district telecom committee
My lord.
for disposal. If there is any individual or public grievance relating to establishment or operation of a mobile tower. And they have to dispose the order. And thereafter, if you are aggrieved, you have an option to prefer an appeal to the State Telecom Committee. All these are there. Why should we enter in this?
I have already submitted a.
District Telecom Committee. Information Technology Department has formulated guidelines for issue of clearance. What is, you have a next?
At page 34, my lord. Department of Telecommunication Advisory Guidelines for State Government.
Thereafter, state government has issued the guidelines for issue of clearance and permit for installation of mobile tower and disposal of public grievances in this regard. On 11/8/2015. আছে নেকি আমার? উলাই থওক। Mr. I alumni council for petitioner shall place a copy of the guidelines for issue of clearance and permit for installation of mobile towers and disposal of public grievances notified by the Information Technology Department, Government of Assam on 11/8/2015 on the next date of listing. List the case on Wednesday. We'll find out. Huh?
Monday, my lord.
Monday is too short. All these are holidays.
Madam 12.
My lords,
Hmm.
your lordships, the present petition involves repealing ordinances as well as bills, my lords. If it may be
Okay.
placed before the appropriate bench.
Which are the ordinance?
This.
Mr. Hendrik,
Lordship, it has gone out that pending before the division bench. Lordship, मैं खाली
which is the ordinance?
The ordinance is at annexure 11, my lords,
Page?
page 94.
This is under challenge.
This is under challenge, my lords.
Mr.
Adil Ahmed.
A. Ahmed, learned counsel for a petitioner, and Mr. J. Hendrik, learned state counsel.
no Lordship, I appear on behalf of respond number 3 and 5.
State, okay, Miss 3 and 5. You are 3 and 5. MS Borua. Petitioners, huh? I love it. Petitioners of it, just about. My junior government advocate, Assam for the response number 1, 5, and Mr. J. Hendrik, learned standing counsel, revenue and disaster management within bracket, registration department. For the response number 3 and 5 have submitted that as the page 94. Assam Ordinance number Roman 4 of 2024 within bracket the Assam repealing ordinance, 2024 bracket close, whereby the Assam Muslim Marriages and Divorce Registration Act 1935 has been repealed. In the is the subject matter of the subject matter of challenge in this writ petition, the writ petition is to be listed before a division bench. Post of the registry to look into the matter and list the writ petition accordingly before the appropriate bench.
My lords, if the same may be listed within 2 weeks or so.
I do not direct
Very well, my lord.
to be before on this date.
Very well, my lords. Very well.
Division bench may direct.
Deeply obliged.
You have to respect the hierarchy.
Yes, ma'am. Obliged.
Item number 14.
Matter relates for demarcation, my lord. The petitioner.
Demarcation.
Petitioner is the joint partner of land.
Let us fix a date, Mr. Islam. We'll go together for demarcation.
In person.
Subject matter is what?
In person.
Perfect.
In person, so office member.
Demarcation and Batuara.
My lord.
Partition.
Initially, I filed the Batwara case, but without a report of the boundary demarcation, my lord, Batwara is not possible. The petition was stated.
It is what
That is
partition is perfect or what?
That is why I filed this representation, several representation that was not considered.
Representation will not do. You have to make an application under the Public Services Act perhaps. The subject is under Public Services Act or not. Deposit proper fees, proper application for demarcation,
Interference of office,
notified subject.
office memorandum is 21st December 2020.
Which page? Which page your application is?
Application is page 22, madam.
Article 23.
Particular
23.
23. বাটোয়ারা বিচাৰিছো স্থানীয় গাঁওবুঢ়া অনুমতি প্ৰদান কৰিছে who is the local গাঁওবুঢ়া he cannot do. I think partition is under the Assam Land and Revenue Regulation.
Yes.
Gaura cannot do.
Madam, only certificate that he is the resident of that local. And
You have 10 viga, 2 katha, 10 lesa.
madam. And he's.
You want what? Demarcation and Batwara. So out of 24 bighas,
10 bigha, 2 katha, 10 lesa.
whether there was partition. Whether there was partition? No partition.
No partition.
But the partition is a subject matter of public service. No. Some Land and Revenue Regulation.
No.
No.
Well, now my petitioner humble prayer only make a direction to demarcate the land. Then after getting that demarcation.
No, it is a Asmali Patta.
Asmali Patta now.
Then,
Joint Patta.
then
And revenue is.
how can it be demarcated? Tell me first. Tell me first. Asmali Patta,
Asmali.
how it can be demarcated? Tell me.
That is why we'll file the.
Recorded for, it is under chapter 6. Partition. Your grievance is that despite 10 bigha, you are paying revenue for 24 bigha.
24. For entire.
You want a separate assessment. Before whom he is finding?
Circle of Victim.
Yes, Mr. It is there under chapter 6. Notification of application. The deputy commissioner shall, if the application is in order and not open to objection on the face of it, publish a proclamation at his office and at some conspicuous spot. Your prayer is partition and demarcation.
Especially, my lord, the petition prays for direction to demarcate the land. As regards, my lord, after demarcation, my lord, Batwara can be done. And the joint partner also have no objection, my lord, in Section 6, my lord, page 26, my lord.
Yes, Mr. What to do?
Demarcation can be done.
Would you want to take instruction about the status of this application? Or we shall issue notice, which will go for 1 or 2 years? Huh?
They can apply for demarcation first.
But demarcation, there was no Asmali Patta. What is your service? Let us see demarcation service. A public service demarcation. Do you have a copy of the notification regarding demarcation? Huh? It is there, perfect partition. It is there. Perfect partition in case of no objection from co-patadars. You have that?
My lord, annexure 6, my lord.
You have that?
Yes, annexure 6, page 26, 27, my lord. SMS vernacular is page 27, my lord. বাটোয়ারা করাত আমার আপনা
You file an application under Public Services Act. It will be done. And demarcation was in it. Ase. Heard Mr. B. Islam. Learned counsel for the petitioner. Perfect partition is part of that service. MS G. Hazurika, learned standing counsel revenue department for the respond number 1. And MS Mr. N. Goswami, learned junior government advocate Assam for the respond number 2 and 3. First of para. The petitioner has projected that he is a joint patadar of a plot of land measuring 24 bighas, 1 katha, 17 lesas, covered by periodic patta number 24 and dag number 134, situate at Revenue Village number 2, Bongalbari, Mauja Gobha, Mayong Revenue Circle, District, Morigaon, along with 4 other pattadars, co-pattadars, postal. It is a further case of the petitioner that out of said 24 bighas, 1 katha, 17 lesas, he has inherited a part of it measuring 10 bighas, 2 kathas, 10 lesas as a legal heir of his deceased father, late Kala Sikh. Full stop. Due to situations beyond his control, the petitioner has been paying land revenue for the entire parcel of land measuring 24 bighas, 1 katha and 17 lesas since a long time, and as a result, the same has affected his financial condition. Full stop. Para. The petitioner has projected that seeking partition and demarcation of the plot of land, belonging to, inherited by him, measuring 10 bighas, 2 kathas, 10 lesas from the joint patta, joint periodic patta, we didn't make it as Mali. He had approached the circle officer, Mayong Revenue Circle, by filing an application on 6/8/2024 for demarcation and partition of that part of the land. Full stop. The petitioner has further projected that for such demarcation and partition, comma, his co-patadars has issued a no objection come consent certificate. No objection certificate, right?
Right.
You are saying?
Right.
Full stop.
No objection.
Para.
An extra 6 days will be taken.
The Assam Land and Revenue Regulation. Chapter 6 of the Assam Land and Revenue Regulation deals with partition and union of revenue paying estates, full stop. As per section 96, comma, quote unquote, perfect partition, unquote, means the division of a revenue paying estate into two or more such estates, comma, each separately liable for the revenue assessed thereon, full stop. As per section 97 has provided, has described the persons entitled to partition. And as per section 97, comma, every recorded proprietor, every recorded landholder, comma, if he is in actual possession of the interest, comma, in respect of which he desires partition, comma, can claim perfect partition. Full stop. Full stop. Both para. Perfect partition. In case of no objection from co-patadars and demarcation are notified services under Assam Right to Public Services Act. Full stop. Para 7, by an office memorandum. By an office memorandum লিখিব এটো কোড কৰি দিব তাৰপিছত লিখিব ইয়াৰ para 17 তাৰপিছত para 8 লিখিব demarcation আৰু perfect partition দুইটা সোমাই দিব in deposit fees there are fees 500 rupees something all this
Right.
approach
Money.
disposal
Yep.
you approach the proper forum
Yep.
I have directed the appropriate authority will consider and proceed with the matter in terms of so and so within the stipulated time
Yep.
period.
Item 15.
Yes, Mr. Borbhuya.
My lord, this petition is, my lord, in a very narrow campus, my lord, because, my lord, practically, my lord, our land is going, my lord. But as per their notification, my lord, for the entire village, only, my lord, less than 300 feet land is taken, my lord. This is the case, my lord. In this regard, my lord, they are submitting, my lord, representation time to time, my lord, but no result. And last one is, my lord, annexure 8, page 52 months.
So there are two petitioners.
Two petitioners, my lord.
What is the grievance? Your patadar,
But-
your landowner of
Yes.
what plot of land?
Yes, my lord.
Commercial land,
commercial, my lord, roadside.
roadside land,
But village area, my lord.
village area. What is your area?
Area, my lord, this is patta number, my lord, 342, dag number 569.
I can understand. What is the total area
Total area, my lord, they are saying.
of that patta land?
Total area is, my lord.
If you don't know, then how can I know?
Yes, my lord, but they are, my lord, guessing, my lord, at least, my lord, 1 bigger land is going, my lord. From
No,
their.
one minute. Tell me, what is the,
More than 1 bigha.
you are owner of what? What area of land?
1 bigger, my lord.
Owner of 1 bigha.
Yes.
Are you living there?
Our shop is there, my lord.
Hmm?
Shop is there, my lord.
No, shop is no more.
Now, still there, my lord, they are.
But they have taken up 1 bigha. According to your petition.
They are, my lord, demarcated, my lord, our land. But in the notification, my lord, they sold. My lord,
Mr. Borvia, first you tell me how much is the area owned by you?
1 bigger, my lord.
Where from?
In this land, my lord.
I don't know. There is nothing in paragraph 2.
In the page
My lord, page paragraph 3, my lord.
Paragraph?
Paragraph 3, my lord.
Where is that? You are owner of.
Yes, my lord.
Where is that?
The construction or for the construction of NH 17 through the Dhubri district, a huge quantity of road side commercial land belong to petitioner and others co-partner.
Why you are bringing other pattadas?
Yes, my lord, my lord. Now, my lord, last 4.
Okay, tell me, patta number 3, tag number 569. How much
Yeah, my lord,
belongs to you?
yes, thereafter, my lord, it is stated, surveyed and demarcated in the field level practically by the concern or respondent authority.
Not
where
there.
Petitioner's land would be more than, my lord.
Not there. That how much is owned by you?
I am, my lord, possessing, my lord, for the.
Possessing is one thing, owning is another thing.
Yes, my lord.
Don't mix up two.
Yes, my lord. In the, my lord, part.
No, you are no land document.
Jamabandi, my lord, page.
Tell me how much? Where is your entry?
Entry, my lord, page.
You want me to go through this Jamabandi
Page 11.
containing 50
Page
entries?
11, my lord. Page 11. my lord. Serial number, my lord, in the entry of the Jamabandi.
Mr. Borvia, you have done everything, but you have not mentioned in this 60-page petition that how much is owned by you.
Well, 1 bigger, my lord.
Where is that?
Paragraph 3, my lord.
No, Mr. Mr. Borvia,
Yes,
don't
my
try
lord.
to.
Yes, my lord, that even. This one, I. Only, my lord.
That I have 1 bigha or 2 bigha, and my 1 bigha land is encroached by the NHI authorities for the purpose of acquisition, and only 10 lesser is
Yes.
shown. To understand that, I have to know that how much land is owned by you. Why you are not making that point?
Yes.
Because you are encroaching on the load by the shop, by that shop. That is why you are not telling the truth, perhaps.
No, my lord.
Then why don't you come up that I own 1 bigha land or 2 bigha land? Why you are not telling that in this 60-page petition? Mr. Goswami is going to find out how much area is owned and you are not telling. Come up with that. We'll take up on another day.
Submit, my lord, about the.
Tell me,
total land.
who is the land document? Please come up with that. On the prayer of Mr. A.M. Borvian, Learned Counsel for the petitioner. This is the case on Wednesday. We cannot issue notice just for that. You come up with that, I have 2 bigha. And National Highway authorities have encroached 1 bigha. But they're paying only compensation. They're assessing the land only for 10 lesser or 20 lesser, like that. No. Come up with clear facts.
Item 33.
এইটো ক'ৰবাত দি থৈছিলো আবেলিয়াৰ পিছত after a break.
Last occasion, where I also heard the matter, my lord.
These two decisions are not on 43.
No, I'm coming to that. We are dealing with page 20, annexure D.
Page
Letter of the-
20.
Letter of the executive officer to the chairperson. Whether this is maintainable.
Hmm?
Whether this is maintainable.
Is invited.
Whether this is maintainable. There is-
Some municipal act.
Yes. You will also kindly see annexure D. With reference to the subject slightly above, I would like to inform that
2050.
10 numbers of ward commissioners have lost confidence upon you, and to prove your majority, a special meeting needs to be convened under section 43 of the Municipal Act 1956. Therefore, kindly arrange for a special meeting within 20 days from today. Now, my lord, you are also kind to this. I got a reply, my lord, in the judgment of this court, two judgments of this court. My lord, first come to 168. WC number 168, paragraph 168, paragraph 12. Last sentence, my lord. Therefore, the district commissioner shall also not have any power even to make a request to the chairperson or vice chairman to convene a special meeting for the removal of the chairperson or vice chairman. Even it cannot make a request. And that, my lord, that analogy is applied, my lord, in the next judgment in 2868 of 2024, paragraph 19. Having dealt with the power of the district commissioner, my lord, now the honorable court is dealing with the power of the
Paragraph
19. His lordship got department. Yes. From a perusal of the observation made by the coordinating bench of this court, it is apparent that the district administration has no power to interfere with the proceedings of removal of a chairperson or vice chairperson. The same analogy duly applies also to the case of the executive officer, in as much as the provision of Act 1956 as amended up to date also do not show that executive officer of the municipal board had any control over the removal of the chairman, vice chairpersons or holding of such meeting. So, my lord, here the first judgment says even the request cannot be made. In the, my lord, that case, this was the request made by the district commissioner, my lord, to the I have annexed that, borrowed that letter also, my lord. In the Silapatha Municipal Board, yes, my lord. That was the request made. So, my lord, here also, my lord, the executive officer has not only, he has gone further to say that with reference to the subject cited above, I would like to inform you that 10 ward members of ward commissioners have lost confidence upon you and to prove your majority. A special meeting needs to be convened under section 43 of the Assam Municipal Act 1956. Therefore, kindly arrange for a special meeting within 20 days from instance. It's more than a request, my lord.
Your argued judgment.
My lord.
Your argued judgment. One more from my side. Take one copy more. Your argued judgment. One copy more from me. Para 28.
Para 28.
Another copy.
It was my argument only, not the reason.
No, what is finding? Not your argued case.
Yes.
And the finding.
All these cases are my argument.
Yes.
Earlier two
Yes. So finding. Paragraph 28.
Yes, I'm just going through. Does not provide for whom the execution shall be given.
What mischief can be committed by the chairman?
Yes.
So somebody has to brought this thing to notice. Kindly arrange. He is a part and parcel of the municipal board. He is not district commissioner. Outside body.
No, even
Under section 52.
yes, even my lord, then there was no amendment to this. When this
I don't think these two judgments are applicable in my view.
Yes, my lord, because even
Read it. Let us read together. Let me have a copy.
prior to the
Let me
amendment.
have a copy. Let me have a copy myself so that we can read together. Paragraph 28.
Shall be given. There is no.
Yes, let us read together.
Yes.
So that Mr. Roy can also
Section 43
participate.
does not provide to whom the requisition shall be given. There is no requirement of service of notice personally to the chairperson, and therefore it is not necessary that the requisition has to be personally served on the chairman or vice chairman as the case may be. Section 42, warrants calling of a meeting. This was a meeting on a requisition signed by not less than 3 commissioners. The chairman or vice chairman must have information of the requisition so as to enable them to call a meeting within the outer limit 20 days. The chairman and the vice chairman are elected by the commissioners, which in other words signifies that they had the majority support at the time of the election. They may lose confidence of their electors with the passage of time, and if in terms of the provision of the Act, requisition is given complying with the requirements of the special meeting to discuss a no confidence motion, it is imperative that the special meeting is to be held to discuss the no confidence motion under section motion. Section 43 is a safeguard given to the requisition list because a chairman, vice chairman can ignore a requisition and not hold the meeting to frustrate the requisition. It is equally possible to checkmate the chairperson so and so and so. The requisitionist may profess to have brought the requisition to the notice of the chairman without really doing so. There is a time limit 20 days before holding the meeting from the date of the requisition made. On failure of chairman to hold the special meeting within time, as it appears the requisition can hold a meeting immediately thereafter. This is of some moment importance. On reading of section 42 together, this court is of the opinion that the legislative mandate demands that the requisition must be brought to the notice of the chairman and vice chairman. There must be some evidence and material to show that the conclusion can be arrived at that requisition was so brought to the notice of chairman, vice chairman, Since the right has been conferred upon the requisitions to convene the special meeting within 20 days after 20 days of the execution, in order to enable them to exercise that right, the requisitions must be able to show some acceptable material that the chairman, vice chairman, or so was personally or through any other method, or that requisition was brought with the notice of the chairman, vice chairman, through intervention of any authority in an official manner. If any functionary within the town committee establishment is trying to play truant and cause mischief by trying to side with the either of the two camps, as alleged in this case, appropriate steps can be usually taken to ensure the imperative of the section 2. In the instant case, the notice that shows this clearly
28 is enough.
Mala?
28 is enough.
28 Mala, there is nothing, no finding at all about the power of the district commissioner or
This is the power.
That I didn't.
Kindly arrange.
Mala?
Kindly arrange. The wording is kindly arrange.
No, in 28.
He has been reminded and he has taken this thing on official record so that both sides can take benefit of it.
No, here in 28 Mala, there is no power of the deputy commissioner then or the executive officer defined. There is no such thing. Only the
But
who can hold
chief
the
executive officer is a member of the board.
member of the board, but this
Whole
board is-
time, but has no right to vote, but he
Yes.
has right to attend, and executive power for the purpose of carrying out the provisions of this act
Yes.
shall be vested in
Even
the
under
safe
section 11
executive
manner.
officer.
Even the government nominated officers. except
Anything more?
Mala?
We have gone through your judgments, these
Yes.
two judgments.
But here it is clear that even the executive officer has no right to even make a request following the earlier judgment.
Okay, I'll record your contention.
Yes.
I record your contention.
But Mala,
And
this
I have the
judgment
discretion
is-
to observe my, make my observation.
I also got the discretion to argue my point, Mala.
Huh?
I also get the discretion to argue.
Yes,
what-
please, please.
And one in this 2015 judgment was then there was no amendment to this act.
These judgments then will be effectively par incuriam.
And these two judgments. And matter the later judgment, even by two judges, holding same view. And these were the my lord judgment.
Okay, what are the points then? You tell me.
Just a minute, madam. So my humble submission, this judgment is not applicable because here the court had no occasion to deal with the power of the district commissioner, deputy commissioner or the executive officer then.
Here also we have no power, we have no occasion to deal with deputy commissioner. We are to deal with chief executive officer.
Executive officer.
Right.
And executive, this court has held.
And there the chief executive officer in the second case, he had meddled and interfered with the proceeding. And in my view, page 20 is not interference with anything.
No. Yes,
This
my
is
lord.
your submission,
Yes,
my tentative
submission,
view.
It is an interference because he ought not to have written this letter.
Mr. Sharma, I have a,
It
I think,
automatically, my lord, what I am submitting, you also kindly note it. The power under section 28 and 43 automatic flows. He need not even request or remind me. He has no authority to at all even.
okay.
If your lordship's analogy.
So he has no power to remind you also.
No request.
Okay.
Here not only.
Okay.
He requested, he went further.
Okay.
Section 20 and section 43. It is the total discussion of the ward commissioners and the chairman, vice chairman,
Okay.
to call the meeting or not to call the meeting. If they do not, if the chairman doesn't call the meeting, after 20 days, the commissioner will call the meeting. But he is nowhere in the scene. So for this democratic process is concerned.
No way in the scene.
Yes. So he may not only, my lord, is against, and this earlier judgment, 2015, had no occasion to deal with the power. There was the simple question of whether notice was duly served on the chairman, and because then my client was chairman, whether he was duly served or not. That was the main question.
So
there.
indirectly, you have admitted that this notice
Yes.
on 14/10,
Yes.
2024 was served upon you.
No, that's why I'm before your lordships. Otherwise, I would
Okay.
have said I didn't know.
Okay.
Now my third point. Your lordship kindly come to now section.
We are only on the interim prayer.
Madam?
We are only on the interim prayer. We are not deciding the writ petition.
The interim period, yes.
Yes.
Now my lordship kindly come.
Whether anything is to be stalled at this stage or not. That is the issue.
Yes.
If or repetition is allowed, you will be, if something happens in the meantime, and if illegality occurs, you will definitely be reinstated. There is no question about it. Question is about passing an interim order.
Yes. Now,
By interfering with this 14/10/2024 letter
yes.
as a matter of interference.
Yes.
That is the only issue here.
Now, my lord, the requisitionists were in 10. We comprise of 17 members, ward commissioners, including MP and MLA. They have got the right to vote and participate under section 11. Now, my lord, when a notice of no complaint is given in earlier cases also, all the commissioners, ward commissioners are to be invited, because now these persons, one or two barring, one or two or three.
Now, who will call?
No, when the requisition is given, notice should go to all. Because what is the problem?
Is this your submission?
Yes.
Okay, that requisition has to serve the notice.
They have to, because they have addressed.
Okay. I'll record that.
Yes, because
Requisitionists
to give
are to serve the notice upon all the other members.
all the members of the board.
Okay. Notice to all the other members of the board. Okay.
Because what happens here, suppose here 10 members, there will be one or two siding my side at the side. So they will certainly vote against me. Suppose out of 10, 7 vote against me. But 7 are not at all giving the notice of no confidence.
Notice. Okay.
So
Okay. I'll not say anything.
half of the people will be out of this notice, purview of the notice. So it is incumbent on the requisitionist to at least notify that we are bringing no motion against so and so, against this chairman, vice chairman. So that they are notified in early. And when the meeting is called either by me or the 3 members of under section 43, then of course notice will go to all. That has to be. When meeting is scheduled on a particular date, then notice will go to all. Tomorrow here, nobody knows. That MP doesn't know, MLA doesn't know, nobody knows. The requisition has been given. So that is my point.
Where is the mandatory provision that requisition is to be? We cannot read something into it. Where is the requisition?
My lord,
requisition. Mr. Sharma, you are seasoned and
yes, I know.
But this time, this kind of argument I have heard it for the first time.
For me, my
The requisition is,
for me.
while submitting the requisition, has to inform the entire other board members that we are submitting a requisition.
Because they had,
I have heard it for the first time.
My lord,
Where is
no.
the provision for
No, no.
requisition?
They are to know, because give everybody inform that. we are
Mr.
giving a-
Sharma,
No, this is my submission, my lord, may rejected, accepted, there is different thing.
Okay.
One more thing, my lord.
which one? Which one is the provision?
For me, my lord,
Requisition.
here in this act, my lord, many things are missing. So that exact provision is not there. May
By
be-
resolution, or maybe removed by resolution. Where is the requisition provision?
my lord, section 28.
No, there is voting.
An elected chairman of the vice chairman may be removed from his office by a resolution of the board.
That stage is yet to come.
more than half of the whole number of commissioners shall have given their votes at a meeting will convene for the purpose. Whole members of the court.
We are in 43-2 only.
Yes, 43-2.
We are at this stage 43-2. Section 28 stage is yet to come.
Yes.
And we cannot, is there any rules? Because section 43-2
Yes.
does not say anything about anything. Actually,
No,
only on a requisition by not less than 3 of the commissioners. So we cannot read something into it which is not there. Is there anything in the rules? Any rules?
So of course, I have not checked.
Yes.
Then there is third point. You will also kindly come to section 29.
One is direct interference by chief executive officer.
Yes.
Second is requisitions are to serve the notices to all the other members of the board at the time of submission of requisition.
Yes.
Okay.
And I am certainly relying on 2 judgments, my lord. 160.
Sure. That is not to be ignored. And third?
Third is, my lord, section 29. There are 2 independent provisions under section 29, my lord.
30?
29.
29. But this is misconduct. 29.
No, let me argue, my lord. There are two separate provisions, distinct provisions. The state government may remove any elected commissioner on the ground of his misconduct. A lot of kindly mark the word misconduct. In the discharge of his duties, if the removal is recommended by the resolution of the board, passed at a meeting, special meeting called for the purpose and supported by the votes of not less than 2/3 of the whole number of commissioners of the municipality. That is one provision. Now, full stop there. It is now second provision starts, my lord. Here, my lord, the first provision, my lord, there must be a resolution of the board by 2/3 members, and there should be recommended to the government, then only government can take action. Now, in second, the state government may remove any commissioner. You will also kindly come directly to C and G. If without an excuse sufficient in the opinion of the state government, he absents himself from 4 consecutive meetings of the board. Is it necessary? How many? Yes, there's one. Now I will come to G. If he is in areas of any kind of dues to the municipality for more than 6 months after a bill or notice has been duly served upon him. So only response 6 in the petition. Here the due since 2016 till date. And there was an inquiry asked for the Election Commission of India. If he was under dues to the municipality, how he contested the election. And FIR has also been filed against him. Response 6. He is one of the first signatories of the pilot requisition. So my summary, he is disqualified to give. Then, my lord, you will also come to paragraph 15 of my petition. Paragraph 15. That the private response, namely 1. Pulak Setia, ward number 19, 2. Babul Sen, ward number 13, 3. Tarun Pratap Singh, ward number 15, 4. Pradeep Kumar Das, ward number 3, 5. Indira Roy, ward number 1, 6. Ashok Agarwal, ward number 10, and 7. Dhiraj Singh, ward number 11, were consecutively absented from the 4 boards meeting convened by on so and so date. The boards would not be held due to non-acceptance of the notice on 29 also. They refused to take the notice for boards meeting. So this was intimated with government also. The petitioner is intimated with government also. So, my lord, My submission, they are disqualified to give this notice of requisition.
They are liable to be disqualified
Yes,
and removed.
yes. So 8 members out of 10 matter are disqualified by operation of law. And the respondent 6 matter is facing criminal proceeding.
And who attracts 29 2Z?
My lord, Pulak Setia,
Respond number
6.
yes.
6. Oh, sorry. Sorry, my lord. This is respondent number 9.
Respond number 9.
Yes. And one more submission I had made, my lord, lots of remember that second no
4
confidence.
submissions you have already made. Yes.
Second no confidence motion. The lords will kindly see the language of the requisition.
Second requisition. After withdrawal of the first one.
Yes. They give the first one on 18/7/2024 and withdraw it on their own on 25/7/2024. Again,
Is there any statutory limit?
there is nothing. One thing, my lord, you will also certainly consider this point because why I am submitting KC where then about 60 years back had said Indian law, Indian constitution and Indian laws are what the judges say it is. So it will be what your lordship says it is. If there is gap and there is, my lord, lacuna in the.
No, there is always a scope of fallibility,
Yes.
and that there is a scope for correction also
Yes.
everywhere.
So
That is how it is to be tested.
yes, that's
And
why
ultimately, it is to be finalized
by
in a
the-
different forum.
No, that's what I am now quoting while KC where in 60s years, a big political analysis, I thinker of England, the Indian constitution, Indian laws are what the judges say it is. So a lot of me say
But
it is.
apparently, you have lost confidence of the majority of the people.
No, majority matter if they are all are minus, my lord.
Here, first and foremost constitutional principle is that every institution, democratic institution, is to be headed by a person who enjoys the confidence of all the other democratically elected people. It appears prima facie that by submission of 2 requisition, it appears prima facie that you are losing the confidence of other democratically elected people.
I was also democratically elected.
You are also.
Now, my lord, kindly.
This is the say
You'll also kindly come to the. First
this is
issue.
democracy,
Yes. The democracy may play anything, my lord.
constitutional principle. What to do?
You'll also kindly come to page 17, Annex A. This is the first requisition meeting.
I have seen also. Then it was
Same
withdrawn.
language. Same language. There is
It
no-
was withdrawn without any showing reason. There is not requirement.
And my lord, second withdrawal also same. No reason is given. Third, my lord, same. No reason is given.
Now, how many? First one, then it was withdrawn.
Yes.
Then second. This is
Second.
second. We are concerned with second.
So, my lord, whether that should be encouraged, my lord, whether it will create an impediment in the functioning of democratic elected chairman or vice chairman of the board. Where there are projects going on. And ONGC also is interested to take up the projects. So, these are my submissions. There are altogether 4 submissions, my lord.
In fact, 5.
Your lordship may add, my lord. By deciding the law, setting the law.
No, I am not setting the law. I am only deciding on the interim prayer. And that is not final.
No, not that.
It is only tentative view.
It is to be hard, my lord, yes.
It is to be hard otherwise.
So, my lord,
But so far as stalling a democratic process, we are considering that.
yes, that is true, my lord. One thing more I will
It
say.
is not final.
No. Only one more submission, your lordship may kindly note. Suppose your lordship is finally hearing the matter in the ultimate analysis. Now, if your lordship does not pass the interim order, then my petition may become infructuous. Because
No,
what,
you have
my
a
lord?
provision for appeal.
No, appeal, my lord, when I suppose fail before lordships, can I actually better, my lord?
No, no.
Because that is one thing I must appreciate.
No, that is the hierarchy
No,
of
that's,
courts.
no, one thing I must appreciate from your lordship that your lordship has sufficient patience to hear us.
I have heard you.
Yes. Yes.
Yes, anybody, these private respondents are there or not? Before this court?
No.
No.
Had they been there, I would have heard it finally in the next week.
Yes.
But they are not here.
Not here. So notice.
So we have to decide on interim period. Otherwise, we could have heard Mr. Roy as well as the other private respondents on the main writ petition. Yes, anything?
Nothing, Lordship. My only submission is that all members are not required to be informed at this stage, and this requisition, and this is only an intimation to the, not a calling of meeting. That's holding the process.
Heard. Mr. R.P. Sharma, learned senior counsel, assisted by MS
E Deca.
D. Deca.
A Deca.
A. Deca. Learned counsel for the petitioner. Respond number 1, who represents Mr. N. Goswami, learned junior government advocate, Assam, for the respond number 1, 2, and 3. And Mr. S. S. Roy, learned standing counsel,
Lordship. 4 and 5.
Tinsukia Municipal Board, for the respondent number 4 and 5. Also. In the municipal, in the election for the commissioners to the Tinsukia Municipal Board, comprising of 15 wards, held on 12/12/2022, the petitioner was elected as a ward commissioner by direct franchising. Full stop. The respondent number 6 to respondent number 15 are also elected ward commissioners of the Tinsukia Municipal Board. Full stop. The concerned member of the Legislative Assembly, MLA, and the member of Parliament from the jurisdictional area are also members of the Tinsukia Municipal Board by virtue of their position and Section 11 of the Assam Municipal Act, 1956. Post. The petitioner, it is nominated or generally elected?
Who, madam?
Chairman, is it chairman?
Elected, madam.
Petitioner, because
Elected.
you have said nominated. The petitioner was thereafter,
Elected by the 15 members.
petitioner was thereafter elected as a chairman of the Tinsukia Municipal Board. Full stop. Para. The on 18/7, (2024), 10 number of ward commissioners submitted a requisition expressing no confidence against the chairman of the Tinsukia Municipal Board, that is, the petitioner, seeking convention of a special meeting for consideration of the motion of no confidence brought against him. However, by a subsequent letter of withdrawal dated 25/7/2024, comma, the earlier requisition dated 18/7/2024 was withdrawn by the said requisitionist, full stop. But again on 14/10/2024, comma, the same 10 ward commissioners, comma, that is, comma, the respondent number 6 to respondent number 15 had submitted a requisition before the petitioner expressing want of confidence in him to continue as a chairman of the Tinsukia Municipal Board. Full stop. Close on the heels of submission of the requisition dated 14/10/2024, comma, the Chief Executive Officer of the Tinsukia Municipal Board, that is the respondent number 5, wrote a letter to the petitioner as the chairman, Tinsukia Municipal Board, on 14/10/2024. Full stop. The contents of the said letter dated 14/10/2024 would be adverted to in a later part of this order. Full stop. Para, this writ petition is preferred to assail the requisition dated 14/10/2024, submitted before the petitioner by the respondent number, submitted by the 10 ward commissioners, that is the respondent number so-and-so to so-and-so, and the letter dated 14/10/2024, issued by the executive officer, chief no, the executive officer, Tinsukia Municipal Board, within bracket, respondent number 5, full stop. Para, I have heard Mr. Sharma, learned senior counsel, appearing for the petitioner, has submitted that the executive officer could not even have requested the chairman of the municipal board, like the petitioner, by a kind of letter dated 14/10/2024, full stop, in support of his such submission, comma, Mr. Sharma has referred to two decisions of the coordinate benches in WBC number 2868/2024. আগতে লিখক বেলেগ এটা।
And value 168.
168 stroke 2024, তাত লিখিব শৰ্মিষ্ঠা দেৱ versus so-and-so bracketত and WBC number 2868/2024, within bracket লিখিব লাবণ্য পাইক দলে so-and-so. First of, he has contended that neither the provisions of section 28 nor section 43 permits the executive officer to meddle into or interfere with the with a process of calling for a special meeting on a motion of no confidence. Full stop. He has further contended that the requisitionist expressing any want of confidence in the chairman of a municipal board are required to serve the said requisition to all the other members of the board, since it is incumbent on the part of such requisitionist to serve the requisition to the other members of the board, the requisition dated 14/10/2020 suffers from illegality. Post up. It is further contended that the provisions of section 29, more particularly, clause C and clause G of subsection 2 of section 29 make the respondent number
Paragraph 15, my lord.
yes. Number is not there. Respond numbers are not there.
15 there.
Pulok Setia. Okay. I have to see. Not in the bracket. I thought that it was in the bracket. Respond number 9. Babul Sen. Where is Babul Sen? He's not made a party. Torun Pratap.
Bubble, once it is
Ah.
become basal. Sen.
Basal Sen. Some Basal Sen. Okay, Likhok. Respond number 11. Torun Singh. Torun Pratap Singh. Respond number 8. Pradeep Kumar Das. Respond number 13. Indira Roy. Respondent number Indrani Roy, Indira Roy, so many typing mistakes. Basal Roy, Babul Roy, Indira Roy. Respond number 6. Also Kumar, well, 12. Dhiraj. 7. Liable to be removed as ward commissioners due to their continuous absence for 4 or more occasions in the meetings, board meetings, in the meetings of the Tinsukia Municipal Board. And as such, the requisition submitted by them is clearly non-est in law. Full stop. He has further contended that after withdrawal of the first requisition dated 18/7/2024 by the letter of withdrawal dated 25/7/2024, a second requisition letter on 14/10/2024 by the same 10 requisitionists are not tenable and maintainable in law. Anything more? These are the grounds? Full stop. para, the provisions for removal of a chairman of a municipal board is provided in section 28 of the Assam Municipal Act 1956 as amended. Full stop. As per subsection 2, an elected chairman may be removed from his office by resolution of the board in favor of which there is an amendment, not less than half of the whole number of commissioners shall be given. And there is an amendment.
Yes, no, what happened when this book was printed, it was wrongly typed, as original.
Yes, yes.
Then I pointed out to the writer of this book. Then he corrected an issue in my book.
Hey, no, puroni kam nai. Give me the new one.
Yes. Here now it is yet a lot were reprinted again for that one word. Earlier it was not less than half, now it is more than half.
In favor of which more than half of the whole number of the commissioners shall have given their votes at a meeting specially convened for the purpose. Full stop. From the facts projected in this petition, the stage of voting has not yet been reached. Full stop. The other provision which is of relevance is section 43. And the same is quoted herein below in its entirety for ready reference. Is section 43. In the judgment and order, in the order dated 29/4/2024, in the writ petition WBC number 168/2024, the District Commissioner Dhemaji, by an order dated 4/1/2024, no, the issue the district commissioner, the 9 elected ward commissioners made a complaint to the deputy commissioner Dhemaji, ventilating their no confidence against the chairman. First off, by a letter dated 12/12/2023, the district commissioner Dhemaji forwarded the petition submitted.
There is a call from a senior court, madam. May I leave, madam?
Submitted by the ward commissioners expressing their no confidence against the chairperson, Silapatha Municipal Board, giving 15 days time to hold a board meeting from the date of receipt of the said letter. Full stop. Having regard to the provisions of section 28, section 47, and section 296 of the Assam Municipal Act, 1956, the Honorable Court has inter alia observed that the district commissioner would have no power even to make a request to the chairperson to convene a special meeting for the removal of chairperson. Full stop. In the judgment and order dated 23/7/2024, rendered in the writ petition WPC number 2868/2024, the order dated 29/4/2024 Supra has been referred to. Post of. In WPC number so and so 2868/2024, the executive officer informed the concerned chairman of the board by communication that in view of the impending Lok Sabha election and the model code of conduct, the special meeting which was called by the chairman on 24/5/2024, should be withheld till 4/6/2024. Full stop. It was in that context, the Honorable Court has held that the analogy applied in respect of the district, the same analogy as has been applied to the district administration, would also apply in the case of an executive officer, as the executive officer of the municipal board had no control over the removal of the chairman of a municipal board. Full stop. Para. This court has not found any statutory bar in submission of a requisition expressing no confidence for the second time after withdrawal of a previous requisition. First stop. The senior counsel for the petitioner has not been able to show any provision or authority regarding prohibition of a second requisition after withdrawal of a previous requisition by the same requisitionist. Full stop. Full stop. Para. The provisions of section 43(2) has provided for, has enabled has enabled 3 commissioners of a municipal board to bring a motion of no confidence against an elected chairman of the municipal board. Full stop. This court does not find any force in the submission of the senior counsel for the petitioner that the requisitionists are to serve the copy of the requisition notice to all the other members of the other ward commissioners or other members of the board. Full stop. Insofar as the contention as regards the respondent number so and so are concerned, comma, this court. It is not brought to the notice of the court that the said ward commissioners have been removed from the board by the state government by exercising power under Section 29 of the Assam Municipal Act 1956 as amended. And as such, full stop, as the said respondents are still members of the boards, comma, this court privacy does not find any illegality in their submitting the requisition along with other members of the board on 14/10/2024. Full stop. The contents of the letter date of the executive officer reads as under. Page 20, content लिख लो. Para in the provisions of section 42, subsection 2 and subsection 3 of section 42 came up for consideration in Jyotirmoy Paul so and so 2015 1 GLT 196. Full stop. It has been and the court, honorable court has observed as under paragraph 28. Para. From the text and tenor of the, before that, by the Assam Municipal within bracket Amendment Act, 2024, Section 52 has been substituted, providing for appointment of executive officer. Full stop. Subsection 1 and subsection 2 of section 52 reads as under. From the text and tenor of the letter of the contents of the letter dated 14/10/2024, as extracted above, this court is of the considered view that the executive officer who has the right to attend all the meetings of the board and a whole-time officer of the board, has written the said letter to the chairman apprising him about the provisions of subsection 2 of section 43 of the Assam Municipal Act 1956 is primarily for the purpose of carrying out the provisions of the Act, performing his duties as an executive officer. Post of in such view of the matter, the grounds agitated on behalf of the petitioner for an interim order are found prima facie not merited at this stage. In such view of the matter, this court is not inclined to pass any order staying the operation of the requisition dated 14/10/2024 and the letter dated 14/10/2024, requisition dated 14/10/2024 within bracket annexer C to the writ petition and the letter of the executive officer, Tinsukia Municipal Board, response number 5 dated 14/10/2024 within bracket annexer D to the writ petition. Issue notice returnable in 4 weeks on so and so date. Extra copies to so and so. The petitioner shall take steps for service of notice upon the respondent number 6 to 15 by registered post with AD by within 2 working days. Yes, any urgent matter?
Wait, please, your lordship.
Because court will not be sitting in the second half.
Lordship, I just pray that if the date may be fixed for the matter.
Which one?
Lordship, your lordship had directed the bank to bring on record whether any chief executive officer has been appointed. The auction matter, 55 lakh rupees. So I pray that if this matter could be fixed on 8/11.
I know it.
Item 18.
You have filed anything?
Yes, lordship. Today an affidavit has been filed stating that an administrator has been appointed till the disposal of the other writ petition which is pending before this honorable court regarding the dispute with regard to the members of the board of directors. 8/11, lordship.
No. 8/11. This court has some difficulty. P. Agarwal for the petitioner
Yes, lordship.
and Ms.
Yes,
As does the council party respondent number 2 and 1 and 2 are present. List the case. Outside you.
18.
Yes, Mr. F.U. Barbuya.
That ongoing work with us has been granted, that's why urgency
17.
17.
F.U. Barbuya. Mr. Deuri. Okay. As doctor standing as a PNRD. List the case on.
Actually,
Yes, Mr.
my item is 29, my lord. There is an interim order till today. That may be continued.
Okay, due to paucity of time, Mr. S.K. Deuri, learned counsel for the petition is present. Due to paucity of time, the matter could not be taken up today. List the case. The interim order passed earlier shall continue till the next date of
Item
this.
no. Item number 25. Matter.
Yes.
The forest case, that's USF.
Okay. On the request of Mr. G. Pathak, learned counsel for the petition, list the case on so and so.
20.
Yes, Mr.
I beg to mention item 20, 21, 22, and 23, Milan. Our interim was there, Milan.
Okay. Okay, R.C. Borpatra Guhai, learned senior counsel for the petitioners, and Mr. N. Goswami, learned junior government advocate for the state respondents are present. As sought for by the learned counsel for the parties, list the cases on so and so. The interim order passed today shall continue till the next date of this. 2nd December.
2nd December.
Interim order.
Must
Continue.
Right to extract or quarry a particular mine at the rate of 146 rupees per cubic meter. It's a short issue, Your Honor, but the history of the case seems to be extremely long. But the issue is actually limited. Would your honors permit me to enter into some of the facts? It's a brief contextualization.
No, what is the judgment which is sought to be reviewed?
Yes.
Find it. Page 54.
That's correct. Yeah. And the relevant.
No wonder with the taking the contours of limited scope of review, what is the ground?
Yes, Your Honor. So the ground is, Your Honor, that there's one paragraph, para 11, which leads to this assumption that is created. And it's an erroneous paragraph, actually. And this paragraph has now led to my writ appeal being decided. Because when the writ petition was filed, it was on the grounds of locus. But ultimately, the writ appeal gets decided. Locus is decided in my favor in this order. But a new issue is raised in para 11, which is Mr. S. Biswas, on the other hand, submits that the very foundation of the case is fallacious, as at no point of time was there any order in favor of the present petitioner permitting them to extract stone at the rate of 146 per cubic meter. It is submitted that the order dated 10/10/2007 does not relate to Boleshwar Stone Mahal. And this is the reason, this is found to be true in this order. And it's on this basis that my writ appeal has been disposed of. So I would want to show that this is actually incorrect from the facts on record.
What is the reason
The
in
reason
the
Your-
judgment
Please,
on the order dated 10/10/2007?
Yes. So the order dated 10/10/2007, Your Honor, is reproduced in this judgment itself. So Your Honor may have paragraph 14 of the judgment. The entire order is reproduced in paragraph 14. Your Honor, may permit me to read? Heard, so-and-so, learned senior counsel, assisted by so-and-so, so-and-so. It is submitted by Mr. Horma, learned senior counsel, that the writ petition can be disposed of in terms of the averment made in paragraph 5 of the affidavit in opposition filed by the respondents, which is quoted below. So first thing to note is that paragraph 5 of their affidavit in opposition is important. And it is on the basis of their affidavit in my original writ petition, which is 769 of 2007. In that writ petition, my writ is disposed of on these terms. Paragraph 5 now, Your Honor, becomes important. That with regard to the statements made in paragraph 5, 6, 7, 8, 9, 10, 11, 12 of the writ petition. And now these paragraphs, my entire writ petition is with regard to a mahal called Boleshwar Mahal. And there is actually a confusion of geography, which I'll come to, which is Boleshwar, and there is another mahal called Lakshishara, which is identical.
Let us read paragraph 5 first.
Please, sir. The deponent begs to state that Vide letter date number FRS 98, dated 28/2/2007, issued by the Government of Assam in Environment and Forest Department, stating that in the application filed by Shri Achit Chandra De and two others for reducing the per cubic meter rate, the Governor of Assam was pleased to reduce the rate in terms of Mines and Minerals and Concession Rule 1994. And the rate has been fixed at rupees 146 per cubic meter to permit holder. That's us. As such, the prayer of the petitioner was considered, and hence on this ground alone, the instant petition is liable to be dismissed. So this is the ground. So now it is on the basis of this paragraph. And
where is your permit?
The permit, Your Honor, will find at.
There is no permit, my lord. They had applied for themselves.
No, permit is at para 89, Your Honor, the writ appeal. Is it at?
Show me your permit to crystallize any right in your
89,
favor.
89.
To crystallize any right in your favor as a permit holder.
So the permit is at page 89, Your Honor, which says enclosed herewith the following petition. Further, this
page 89.
89, Your Honor.
There's no 89.
Of the writ appeal, Your Honor. Because it's not in dispute that I had a permit. The entire case of the respondents has been that para 5.
Where is your permit?
That about my lords will come to this apex court direction. They may themselves withdraw the petition. And now they are writing in averment, they have averred in paragraph 1 that there is a direction of Supreme Court, go and file review.
That may not be.
That is everywhere that is the
That may
ground.
not be correct. I apologize for that.
Seek leave before the Supreme Court
And
to approach the High Court, then comes as per the direction of the Honorable Supreme Court. We have filed this review petition. We have seen in many foreign matters. Where is your permit?
Your Honor, the permit is the one that I'm mentioning at this page itself.
Page 89, it is not permit.
This is what actually is the
Tell me, first thing, there has to be a vested right to issue, to seek any writ in the nature of mandamus or something. Where is your right?
The
permit.
Give me a moment to find the permit. Because the issue of the permit was never raised. We did have a permit. We've gone through many writ petitions. The permit has not been in dispute. That is why I have not.
No, where is that permit?
I will show you on. Your Honor, I have page 41 of the writ appeal. I think a clear copy is at page 39. But the issue has always been with regard to para 5. Because the order actually was granted in my favor. If I may just show one.
What is the
document.
permit?
Para 39, Your Honor. Page 39. Annexure B.
Read.
Form of permit for minor minerals to be issued under Assam.
Para 39 here is different. Something 7/12/2007.
Page 39, Your Honor.
Page 39.
Other rate appeal. Permit number Karimganj AMMC 94/6/2018 of 2006. But I will satisfy Your Honor on the issue of the permit, even if that is not the one. Because in my understanding, that's the permit.
Even the permit is also there. Let us assume that permit is there. What effect it will have now? It's 2007 matter, my lord.
That I will show.
That, my lord.
The protection is granted to me. That is not. If Your Honor may just.
No, who are the other appellants or review petitioners?
So there are 4 petitioners, Your Honor. There are 5 petitioners. One of them was held to have no locus. If Your Honor may have the previous order.
No. This permit is solely to omit day.
That's correct, Your Honor.
Then who are the others?
The others also were given a permit, Your Honor. That permit I will find. This is with regard to Amit, but the permits were there, Your Honor.
Let us see the judgment first. Going here and there.
Yes, Your Honor.
Read fully. Don't go here and there.
No,
read
not
fully.
absolutely, Your Honor. I will read it fully. Heard Mr. So-and-so, Senior Learned Counsel, assisted by so-and-so. This intra-court appeal is directed against order dated 2/5/2019, passed in writ petition 949/2019, dismissing the writ petition filed by the appellants and also imposing a cost of 5,000 rupees. It is the case of the appellants that the appellants, along with 2 others, including one Pompa Endau, had applied to the Principal Chief Conservator of Forest Assam for grant of forest trade permit under Assam Minor Minerals Concession Rules, for short the 1994 rules, for the purpose of extracting stone from a quarry called Boleshwar Stone Quarry, which is under the Kalin range of Karimganj Forest Division. Consequently, thereto, each of the appellants were allowed to extract 2,500 cubic meters of stone on 31/2007.
Each of the appellant means meaning thereby all the 4.
This is my submission, Your Honor. This will come to be reversed a little bit later.
It is the case of the appellants. Okay.
It's the case of the appellant, because one of them is actually incorrect here. Consequently, thereto, each of the appellants were allowed to extract 2,500 cubic meters of stone on 31/2007.
That is page 39.
31/2007.
That is page 39.
Second. No, I don't think that's page 39. Page 89. So this is the one, I think this order is referring to the document at page 89. (31 2007) is at 89. Date is wrongly recorded in the writ petition at para 2. Should have been 3/1/2007. On the payment of.
Here with the following petition.
Your Honor, may I continue reading?
Yes.
On payment of forest royalty at the rate of 170 per cubic meter for issuance of formal order. The fixation of royalty at the rate of 170 per cubic meter was the subject matter of dispute in writ petition 769 of 2007. So this is the earlier writ petition. We are in the third round. The said writ petition was disposed of on 10/10/2007. We will revert back to this order dated 10/10/2007 a little later. It appears that the additional district magistrate Karimganj had passed an order dated 31/8/2015 directing the DFO Karimganj to consider the prayer of the petitioners. As the prayer was not appropriately considered, writ petition 5385 of 2016 was filed before this court, and the said writ petition was disposed of by the order dated 9/9/2016, directing the state respondents to consider the representation filed by the petitioners therein. Then came the Assam Minor Minerals Concession Rules 2013, for short the 2013 rules, which came into effect on 16/3/2013. It is to be noted at this juncture that Baleshwar Stone Quarry was subsequently bifurcated into Baleshwar Minor Mine Mineral Unit 1 and Baleshwar Minor Mine Mineral Unit number 2. Baleshwar Minor Mineral Unit number 1 came to be closed on account of environmental issues. So only unit number 2 survives today. A sale notice dated 25/2/2017 was issued by the DFO Karimganj Division for settlement of Baleshwar Minor Mineral Unit 2. Writ petition being writ petition number 1609/2017 came to be instituted challenging the said sale notice. While the said writ petition was pending, the appellants filed the present writ petition out of which this appeal has arisen. Praying for a writ of mandamus to the respondent for allowing to extract 2500 cubic meter of stone from Baleshwar Minor Mineral Unit number 1 and 2 at the existing government royalty of 200 rupees per cubic meter on the basis of the letter dated 31/8/2015 passed by the additional district magistrate Kachar, the allotment letter dated 3/1/2007 till extraction of allotted stone material of 1000 cubic meters. The single judge recorded a finding. The learned single judge recorded a finding that the appellant numbers 3 and 4 were minors at the time when the allotment was given, and therefore they were not entitled to a favorable consideration of the prayers made in the writ petition. It was also noted that the present petitioners were not the petitioners in writ petition 769 of 2007, in which fixation of forest royalty at the rate of 170 per cubic meter was put to challenge, and therefore the very foundation of the writ petition is highly questionable. It was further observed that as 1994 rules have been repealed and the 2013 rules, which now hold the field, provide for a completely different methodology for settlement extraction of minor minerals, after lapse of 12 years from the date of initial allotment, prayers made by the petitioner cannot be granted. On the impression gathered by the learned single judge that the petition was not filed bona fide, cost of 5,000 was imposed on the writ petitioner to be paid to the Guwahati High Court Legal Service Committee. Mr. Chaudhary submits that the learned single judge committed manifest error of law in holding that in writ petition number 769 of 2007, only Shri Paplu Datta and Shri Parthopratim Datta were the writ petitioners and not the present petitioner. By drawing attention of the court to page 167, he points out that except Arpita Devi, all were writ petitioners in the said writ petition. He also submits that in view of the order dated 10/10/2007, passed in writ petition 769, the appellants were entitled to operate the mahal at 146 per cubic meter. But since the present rate of royalty is 200 per cubic meter, the appellants are praying for allowing them to operate at the rate of 200 per cubic meter. It is also submitted that coming into effect of 2013 rules will not have any impact in the present fact situation. Next, para 11. Mr. S. Vishwas, on the other hand, submits that the very foundation of the case is fallacious, as at no point of time there was any order in favor of the present petitioners permitting them to extract stone at the rate of 146 rupees per cubic meter. It is submitted that the order dated 10/10/2007 does not relate to Baleshwar Stone Mahal.
Where is 10/10/2007 order?
Yes.
Where is that?
That's reproduced in paragraph 14. Your Honor. I think, may I just read in sequence? We'll come to that. We have considered the submissions of the learned counsel for the parties and have perused the materials on record. At the very outset, we would observe that the learned single judge was not justified in holding that the present writ petitioners were not parties in writ petition 769 of 2007. It is, however, true that the present petitioner 4 was not a party to the said writ petitioner. The position becomes manifestly clear from a perusal of the order sheet dated order sheet in writ petition 769, which is available at page 167 and 168. However, what is significant is to note that in the letter dated 3/1/2007, annexure 1 at page 89 of the appeal papers, name of only appellant 1, 2, and 4, and that of one Paplu Datta were mentioned. Name of appellant number 3, Amit De, whose son of appellant number 1 was not there. So in this context, so the issue of locus is to some extent decided. Now we come to the main order, Your Honor. Order dated 10/10/2007, passed in writ petition 769 of 2007, reads as follows. Heard Mr. R.P. Sharma, learned senior counsel, assisted by Srimati Christie, learned counsel for the petitioners, as well as Ms. R. Chakravarti, learned state counsel for the respondents. It is submitted by Mr. Sharma, learned senior counsel, that the writ petition can be disposed of in terms of the averments made in paragraph 5 of the affidavit in opposition filed by the respondents, which is quoted below. That with regard to the statements made in paragraphs 5, 6, 7, 8, 9, 10, 11, and 12 of the writ petition, the deponents begs to state that that Vide letter number FRS 98/2003-104 dated 28/2/2007 issued by the Government of Assam in Environment and Forest Department, stating that in the application filed by Shri Ashit Chandra De and 2 others for reducing the per cubic meter rate, the Governor of Assam was pleased to reduce the rate in terms of Assam Mines and Mineral Concession Rules 1994, and the rate was fixed at 146 per cubic meter to permit holder. As such, the prayer of the petitioner was considered, and hence on this ground alone, the instant petition is to be dismissed. In view of the above submission made by the learned counsel for the petitioner, the writ petition is disposed of in terms of the respondents in paragraph 5 of the writ petition in opposition.
What is the meaning of this?
So the meaning of this,
in terms of this, writ petition is to be dismissed.
yes. So now this, they say that my prayer has been granted.
Is Osid and 2 others are you?
Please, Your Honor.
Osid De
Yes.
and 2 others
Yes.
are you?
Yes, Your Honor.
This 5385/2016. Who are the writ petitioners?
I do not have the 5385, Your Honor. I don't think that's on record.
Because Osid Das and 2 others, they were granted.
Yes.
Then, as such,
Your Honor, I hope
please,
that was the.
please understand, Mr.
Yes.
Your name, please.
Drupad Das, Your Honor.
Please understand. As such, you want a similar order.
No. I want enforcement of this order.
That is liable to be dismissed.
Please, Your Honor.
It is as simple as this.
This is appeal of the.
It was as I now
There's some facts
started
that-
recollecting events,
Yes, Your Honor.
as why I was part of this. It was then, are you agreeing to this? You are going agreeing to this paragraph 5. It is that as such the prayer of the petitioner, that means you.
Yes.
Hence, on this ground alone, the instant petition is liable to be dismissed.
Yes.
In view of the above submission made by the learned counsel for the petition, the writ petition is disposed of in terms of the respondents in paragraph 5 of the affidavit.
Your Honor,
it includes the.
Yes.
Yes.
I absolutely agree. Your Honor.
Yes.
Now,
Then.
the answer to this is in para 170.
Then continue.
Okay. Absolutely, Your Honor. Your Honor, may just one thing, may put a pin in this because this order has not been complied with. That is what has happened.
Which order?
This order.
Not required to be complied with. Proceed.
The letter number FRS 98 of 2003, 104 dated 28/2/2007, which is preferred in the said order dated 10/10/2007, is available at page 172 of the appeal papers. The said letter was addressed by the Deputy Secretary, Government of Assam, Environment and Forest Department, to the Chief Conservator of Forest, Territorial Assam. It will be appropriate to extract the contents of the said letter. In inviting a reference to your letter on the subject cited above, I am directed to say that after careful consideration, careful examination of the report submitted by you and the petition dated 31/1/2007 directed by Shri Achit De and two others praying for reducing the per cubic meter rate for extraction of permit from Lakhichara. Now, you want to note that this is Lakhichara, not Boleshwar. My entire writ petition is with regard to Boleshwar. But the document referred to in para 5 of their affidavit and evidence was Lakhichara. That's one of the issues. Kachar division, government of Assam is pleased to state that the rate shall be fixed at par with the nearest mahal, which the nearest mahal is Boleshwar, as per Assam Minor Minerals Concession Rules 1994, and hence the rate has been fixed at 146 per CUM to the permit holder. 16. A perusal of the letter as extracted above demonstrates unequivocally that the rate of royalty fixed at 146 per cubic meter was in respect to Lakhichara Nala, and there is no reference to Baleshwar Mahal in the said letter. A perusal of the order dated 10/10/2007 goes to show that the learned counsel appearing for the petitioner therein prayed for disposal of the writ petition in terms of the averments made in paragraph 5 of the affidavit in opposition, which contains a reference to this letter dated 28/2/2007. Maybe the learned counsel for the petitioner was under a mistaken belief that the letter dated 28/2/2007 pertains to Boleshwar Stone Mahal. The order dated 10/10/2007, passed in writ petition 769 of 2007, does not take the case of the appellants any further. And therefore, the entire edifice that is sought to be built is without any foundation. The order dated 31/8/2005, which is available at 105 of the appeal papers, on the basis of which the claim is now made for extracting stone, has its roots in the order dated 10/10/2007, passed in writ petition 769, and therefore the said order cannot inure to the benefit of the petitioners. The said senior counsel appearing for the appellant has not been able to place on record or before us any subsisting formal order permitting the appellant to extract stone either at the rate of 170 per cubic centimeter or 146 per cubic centimeter. In the aforesaid background, as unfolded, we see no reason to interfere with the order passed by the learned single judge and accordingly find no merit in this appeal. This appeal is dismissed. However, since there was a factual error in the order passed by the learned single judge in the sense that it was construed that the petitioners were not parties in 769, and which primarily was the base for imposition of cost, we are inclined to set aside the order of that part of the order. Accordingly, while upholding the order of dismissal of the writ petition passed by the learned single judge, we exempt the petition applicants from paying cost as directed by the learned single judge. So now my position here is that the statement made in para 11, which says that there is no order that was passed in my favor, is not correct. And this para 5 that is there, they have relied on para
How a permit is to be crystallized? How? There has to be a formal order.
My lord, they are under the impression that they are leaseholders. What I could gather from this, and they want to go back to 2007 on the strength of that permit, my lord. Perhaps it has expired also. They want to go for extraction stones, my lords. And one thing
1994
yes,
rules.
yes.
1994.
Show me the lease in Form L.
The lease in Form L.
There are various stages in the processing of an
I'm aware.
application and resulting into a permit, Mr. Counsel. Show me. Because
Yeah, the lease.
the latest senior counsel appearing for the appellants has not been able to place on record or before us any subsisting formal order permitting the appellants to extract stone either at the rate of so-and-so or at a rate of so-and-so. It has to be crystallized into a formal order of lease in Form L under 1994 rules since repealed.
Very well.
And another subtle issue, my lord, I'd like to point out. We don't
These
have-
are various stages of processing an application, ultimately resulting into a formal order of lease. Thereafter, the right starts accruing. And I remember now started recollecting, wherever you were there in the proceeding.
I was not there. It's my first appearance.
Repeatedly it was asked,
Where is the lease?
where is the lease? Then all these things, otherwise it will flow otherwise from section 78 of 2013 rules. That if rights gets accrued,
Then the section 79 will trigger in my favor.
yes, but where is the right accruing in your favor. Otherwise, all these things are repealed. These will be just mere paper.
I don't believe the lease is on record, Your Honor.
No formal lease. That is what, tell me this is that despite due diligence, you could not produce a formal lease in the form of L under 1994. Otherwise, when a right gets accrued and vested, and if you see 2013 rules, it will be 78 or 79. 79. Any action done and rights accrued. That has been interpreted in many cases. At least some Dakshin Salmar or South Salmar, something like that. What is vested?
South Kamrup.
Kamrup.
Yes.
What is vested?
Yes. South Kamrup, and even that was melody not in principle.
And that was
it
upheld by division bench.
Right. And in fact,
Section 78
and 79.
79, Your Honor.
9. Otherwise, if no rights vested, why should we proceed with the petition or this review petition?
And there,
70.
but there's an impression.
70. Let me have a look at 70.
Rate of stone, it differs from mall to mall. It is not minor. It's a uniform rate through all state. All
No,
the state.
by bringing, I remember now, by bringing this last part of paragraph 5, as such, the prayer of the petitioner was considered. It is already a past event. And hence, on this ground alone, instant petition is liable to be dismissed. And that was asked repeatedly. Osidde was asked whether you or different person. Then considered, it is not is to be considered, considered. And the senior counsel asked, in terms of the above, have you read this word? As such, the prayer of the petitioner in item 769 2007, some of them are the petitioners.
Correct.
First part is related to Osidde and two others. But here, as such, last line, the prayer of the petitioner was considered. It was a past event, happened already. And hence, on this ground alone, the instant petition is liable to be dismissed. And what the senior counsel said? It is submitted by Mr. Sharma, learned senior counsel. The writ petition can be disposed of in terms of the averments made in paragraph 5 of the affidavit in opposition filed by the respondent, which is quoted below. There is a reason behind it. So, in view of the above submission made by the learned counsel for the petition, the writ petition is disposed of in terms of the respondents in paragraph 5 of the affidavit in opposition. And there it was denied. Fixation of your whatever reduction.
That actually.
That is the interpretation code.
There's two documents, Your Honor, may permit me to show.
No, where is the lease?
That I will have to.
Because this is a finding that appearing for the appellants has not been able to place on record or before us any subsisting formal order permitting the appellants to extract stone either at the rate of 170.
So there was
or
an order.
140.
Actually, the issue is, Your
No.
Honor, have
Something which
Yes.
was not placed or not brought on record. Formal order.
There's one document, Your Honor, may permit me to show.
No, is it a review for that?
No, it's in the writ appeal. We had filed this document in the writ appeal. Page 99, Your Honor, may once have. Writ appeal. Cancel general. This is the document that comes.
They are reopening the arguments of writ appeal. It is already dismissed. Review is not
No,
maintained.
this issue was not raised. Because the whole point is that the document has been shown. I'm trying to show a document. If Your Honor are
No,
not.
formal order, Mr. Das. Who is the lead?
You point out the lease if it is a part of the appeal.
Or
I understand. Because over here, Your Honor, may
see,
no, Your Honor, with the last line of this.
that act is repealed,
After-
1994.
After realization of the said amount, you may send the same for formal order in form L from this end.
Where is the form? So because this division bench has already held, reach a finding, no formal order.
Now, if this document was allowed to stand. this
Which
doc-
one?
This document, Your Honor, may I have page 99, please.
I have seen. It
Yes,
is
sir.
before me only.
Yes,
But at best, my lord, it's an in principle approval. Nothing is crystallized. There was no.
but then it
communication
gets
between-
cancelled, Your Honor. Your Honor may kindly Your Honor may kindly see how this letter gets to be cancelled, because once this letter at page 99 is allowed to fructify into me paying them 146 rupees, 146 rupees.
Place me in 1994 rules.
Please, Your Honor.
1994 rules.
1994 rules, yes, Your Honor. I totally follow what Your Honor is saying, that there is no lease that was executed, thus no right has accrued to me as of now.
We are not finding it, or you have not been able to
Yes.
show then
No,
and as on date also.
Yes. And I'm at the point of why this happened the way it has happened. And 101, Your Honor, is the last document. I think beyond this, I would not have anything else to show. I cancels in Korea.
Look, if you go back to that lordship, the case lordship had mentioned that South Kamrup, in there also there was in principle approval. It was held no.
But the in
right.
principle approval has been.
Does not give any right.
Yo,
Your Honor, my last document is 101.
no, I first get myself satisfied whether you have crossed that road or
Threshold.
not. And this is not correct typing, page 99. It should be F. If you turn to 100, something is missing. It is F. So show me form F.
Model
That
form.
was what was insisted when the hearing took place.
So my submission here would be.
If memory of
F
Mr. HRS would have been correct, and had he been present, if I would have asked this question, he should have answered in the affirmative that there was no formal order.
No, there was no formal order. In fact, two submissions, Your Honor, before the matter is ended. Your Honor,
Any wastage of time will invite cost
No.
again.
Your Honor, may please permit me to just two last orders. Document page 99. Page 99 says formal order will be passed at the rate of 146. So I have to deposit this money, then the formal order gets passed. Now, Your Honor, may I have page 101. The order that's passed permitting me to pay royalty at the cost of at the rate of 146.
No, read there, I am saying following petitions. Page 99, I am reading.
Yes, of the rate appeal, Your Honor.
Hmm.
So now I am to comply with this.
Earlier 1994 rules, it was an application. It was the competitive bidding process which has been introduced by 2013 rules was not there. So enclosed, please find a copy of the petition received from PCCF.
Please.
Further, I am sending here with the following petitions in original, whatever.
Please.
For collection of 1000 cm from Boleswar Stone Quarry. You may realize royalty and taxes for collection of the above stone materials. After realization of the said amount, you may send the same for formal order in so and so. So that was the stage in the proceeding, resulting
well.
into a
Order.
formal lease.
Absolutely. I'm following what Your Honor is saying.
Ah.
Now, Your Honor may see 101. This is the last document. I do not seek the same. Now, this is all in the context of the writ petition. Your Honor may see letter number so and so writ petition 769. So this is in the context because this order of at page 99 is passed after the writ petition. The issue covered in this office wider letter dated 769, which is page 99, dated 28/1/2008, is hereby cancelled in the light of the legal opinion communicated by the junior government advocate Guwahati High Court via his letter mentioned under reference. The next paragraph is important, Your Honor. Please file a petition before the Honorable High Court for alteration, modification, or cancellation of the order dated 10/10/2007 in the light of junior government advocates' legal opinion to save the government revenue. So
What is the meaning of this?
So the meaning of this is.
Meaning of this has resulted in release.
Yes, Your Honor, the meaning of this is that my right that had accrued.
Come to that form.
This form can only be fructified once I'm allowed the ability to pay.
Stage of consideration are different, Mr. Even a higher authority may ask for something, but the statutory authority vested with the power has alone the power. He is not to be influenced by any order of any higher authority.
Very well, Your Honor.
Very well. Now, where is the formal order? As simple as that. Why should we go into review of this all these other things when formal order is not there, crystallizing any right
because
to shift into the regime of 2013 rules without compliance of Rule 79?
My submission is, and these are my instructions.
We are not going to waste our judicial time.
It falls under the category enumerated in Kamlesh Verma's case, my lord.
Hmm?
Review is not maintainable, my lord, when the same relief was at the time of arguing the same main matter was negated, my lord. They are opening the same argument again.
No, this issue was not
formal order.
The very fact that there was a direction, not a direction, but an opinion given for.
Let us see your grounds of review.
(22 grounds).
All others will fade if there is no formal order.
But what happens in a situation where I'm prevented from securing a formal order? So the formal order is admittedly contingent.
When no formal order, no vested right. No indivisible right at the stage of process of consideration. Unless and until something is crystallized in your favor.
So what, in my opinion,
that is why the division bench, taking all other contentions, have recorded the finding that no subsisting formal order. That is what all is about. It is not that this paragraph 5 alone.
No paisa. Subsequently cancel. You had made some deposits? No.
No.
Well, in fact, this is no bid. They are no impression that they are granting lease. They apply for a permit that let me extract. And the rate for all mohols are same. They cannot be different rate for different mohol.
No, there was a consideration for this seat day. Seat day, there was a consideration. But here, if you read that particular statement, because I remember now, Honorable Justice, then Acting Chief Justice has asked the senior counsel repeatedly, can you distinguish? Because it was considered, your case. Considered means end of the matter. And court does not have the discretion to reduce the royalty, because the discretion lies with the forest department.
I'm not seeking a reduction. I'm not saying that I should.
No.
I'm saying I should be considered.
Considered. Mr. What I remember now, things are slowly coming back to my mind. Considered. Would be considered. No, it is not the case. If the learned counsel had understood it wrongly, that it is likely to be considered. So in terms of paragraph 5. But when the grievance was heard, it said it was considered, and hence on this ground alone, instant petition is liable to be dismissed. OCID they considered and reduced. Please see the content. Maybe with knowledge or without knowledge, something had crept in black and white.
Yes, I get it.
And it is to be understood in the context by the literal meaning, and it was considered. That is why the Honorable Chief Justice acting at that point of time asked, see, whatever you had done had been done. It cannot be undone now. Order dated 10/10/2007. That was done.
So we are, no, order dated 10/10/2007 is disposed of specifically in view of para 5. So there's no dispute there. And para 5 says.
And this writ appeal emanated from which one?
Please, Your Honor.
This writ appeal
Emanated from 949.
949.
Because the prayers that I'm seeking in 949, Your Honor, that the respondents may consider my case. And if I meet all the criteria, then at least this right to query should be carried over. But it's been long time I've been fighting this battle, Your Honor.
In respect to there is no difference of subject. Petition of the order goes to the Now read again paragraph 16. Now what I have said in the context, a perusal of the letter, read, demonstrate slowly.
A perusal of the letter extracted above demonstrates unequivocally that the rate of forest royalty fixed at 146 per cubic meter was in respect of Lakhi Chora Nala.
I think that is OCID.
And there is no reference to Boleshwar Stone Mahal in the said letter.
Is it correct? Is it correct?
There's no, the word.
Let us read then.
The word
Extracted.
Boleshwar is not used.
Let us read. Let us read.
A perusal of the order dated 10/10/2007 goes to show that the learned counsel appearing for the petitioners therein prayed for disposal of the writ petition in terms of the averments made in para 5 of the affidavit.
Now the way I interpreted, that is what the deliberation was held.
Yes.
Which contains a reference of this letter.
Letter dated 28/2/2007. Maybe the learned counsel for the petitioner was under a mistaken belief that the letter pertains to.
That is what.
In my respectful submission, Your Honor, this letter actually did pertain to Boleshwar. It did not use the word Boleshwar.
We are not going to read Mr. Counsel. This is all.
Taken a judgment out. I couldn't go to parent judgment. So I just.
The reason being, Your Honor, just complete my submission. It says nearest Mahal rate.
Kamlesh Verma has been reiterated, madam. When review lies, when review does not, madam. Paragraph 28. He's trying to reopen the arguments and trying to fish out a document.
I'm not fishing out. I'm reading the document that's there. There is a misconception that Lakhichara that Boleshwar was not considered in this fact.
Who is a Boleshwar?
That's what I'm saying. Boleshwar and Lakhichara adjoining to each other. So the law says that you will get the adjoining rate. So when they present a document to me saying Lakhichara, I'm giving you at 146 and at the rate of the nearest Mahal as per Assam Mines and Minerals, I take it to assume that Boleshwar will also be given at 146. That's in the context why I'm saying that Boleshwar was considered, because my entire writ petition 769 was in the context of Boleshwar. So where is Lakhichara coming in? Only to show that they've given Lakhichara to me, and the nearest Mahal being Boleshwar was, I think, understood at this point. And that's why in my additional affidavit, I put a document to establish that Boleshwar and Lakhichara are adjoining to each other. Thus the rates are identical, as my learned counsel, colleague is correctly saying. It's a uniform rate.
All ends with last line of paragraph 16.
I think I have. I'll rest my case on.
Now, under which ground of review? Which ground? Discovery of new and important matter of evidence?
Some facts that were not considered, Your Honor, is actually. Your Honor, may give-
Discovery is something different, my lord. Non-consideration is different.
Honor, may give-
Mistake apparent on the face of the record?
Any other sufficient reason, Your Honor?
That is related to, again, all these two.
No, I'm resting my case on. I think I follow what Your Honor is saying, and I do not want to invite costs.
And I don't think he's the author of this petition also.
Maybe.
Not.
Otherwise, 22 grounds.
Yes, Mr. Gugoi, anything?
I place the judgment. This is not maintainable. My lord, he is trying to fish out new documents. Non-consideration, new argument. That is my case, my lord.
All boils down to no final order. Heard. Mr. Das.
Didas.
Didas. Learn it. Counsel for the review petitioners. And Mr. D. Gugoi, learn standing counsel. Forest, Environment and Forest Department for the response number 1 to 4. Anybody, State Council? 1, 2, 3.
1, 2, 3, 7. 1,
7.
2, 7.
Full stop. What you wanted to bring through this additional affidavit?
The fact that Boleshwar and
Nearby.
are nearby. But beyond that, I don't think it will carry me much further.
The instant review petition is preferred. Seeking a review of a judgment and order dated 26/8/2019, passed in a writ appeal, writ appeal number 157 of 2019. Oh, it was already marked, question mark, paragraph 1, last 3 lines. Paragraph 1, last 3 lines. When it was moved.
Paragraph 1, Your Honor.
In paragraph 1 of the present writ petition, it has been averred that the petitioners had approached the Honorable Supreme Court by special leave petition number 275556 of 2019 and the Honorable Supreme Court of India by order dated 2/12/2019 had disposed of the special leave petition giving direction to the petitioners to prefer the review petition before this court in view of the apparent error available on the face of the record, and as such, the present review petition has been filed by the petitioners. Full stop. Para. The order dated 2/12/2019 passed by the Honorable Supreme Court of India in special leave to appeal number 27556 of 2019 is appended as Annexure 1 to this review petition. First off, the order dated 2/12/2019 reads as under page 26. Quote Quedo. From the text and tenor of the order dated 2/12/2019, it does not emerge that there was a direction of the Honorable Supreme Court of India to the petitioners to prefer the writ petition before this Honorable Court, full stop. Review petition, full stop. It has emerged that before the Honorable Supreme Court of India, the learned counsel appearing for the petitioners prayed for withdrawal of the special leave petition with liberty to apply for review before this court, and accordingly, allowing the prayer, the special leave petition was disposed of as withdrawn with the liberty to prefer the review petition. Full stop. Para. The order, judgment and order dated so and so, which is sought to be reviewed, is extracted herein in its entirety. Para. The contours of a review petition is limited. Full stop. Without adverting to any authorities, it is settled that only on few grounds a review is maintainable. Full stop. Ordinarily, a review is maintainable. One, discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the petitioner or could not be produced by him, semicolon 2. Mistake or error apparent on the face of the record, semicolon, and 3, any other sufficient reason, full stop. It has been observed in Kamlesh Verma versus Mayawati and others reported in 2013, 8 SSC 320, the words quote unquote, any other sufficient reason have been interpreted to mean quote unquote, a reason sufficient on grounds at least analogous to those specified in the rule, full stop, unquote. Full stop. It has been further held as under paragraph 20.2. A number of grounds numbering 22 have been pleaded in this review petition. Full stop. Para. We have heard the learned counsel for the review petitioners and the learned standing counsel extensively. Full stop. On a pointed query, full stop. The matter of issuing. What is this? Permit? Permit.
Permit.
The issue involved in the original writ petition. In the writ petition, WPC number,
WPC. Please, Your Honor.
WPC number 949,
949.
2019. And in the writ appeal, comma, the writ appeal number 157, 2019, pertain to issuance of a permit under the Assam Minor Mineral Concession Rules, comma, 1994, comma, repealed subsequently by the Assam Minor Mineral Concession Rules, comma, 2013, comma, and the rate of rate to be payable per cubic meter of stone in respect of a stone mohol, namely Baleswar Minor Mineral Unit number 2. Full stop. Para. One of our grounds for dismissing the writ appeal, comma, as recorded therein, as recorded in the judgment, an order dated so and so sought to be reviewed, comma, was that the appellants were not able to place on record or before the writ appellate court any subsisting formal order permitting the appellants to extract stone either at the rate of 170 per cubic meter or rupees 146 per cubic meter. Full stop. Give me the book. Okay. Okay, it is there. In Dakshin Kamrup, there is another one. When within the stipulated period, the binding is not there, lease is not there, it is
Cancelled. Deemed cancelled. Deemed rejected.
deemed rejected.
It, I think
Yes,
old
there's a
rule
deeming
9.
provision also.
Huh?
There's a deeming provision also.
That is a deeming provision. 8.
Legal fiction.
2.
Yes.
Legal fiction.
If it's not query is not
Midnight oils were burned by me also in that case. So I know. The process of mining lease in a regime under the Assam Minor Mineral Concession Rules, 1994. The process of grant of mining lease could be initiated on the basis of an application filed by a proponent. Full stop. The application for grant of mining lease stands crystallized in favor of an applicant only, proponent, only after execution of an agreement in the form F. Full stop. The
Would it be L, Your Honor?
L or F?
L. Under 39, the permits under 39. So 39 one says
30?
may grant a mining permit in form L.
And,
Let me check. 39, 31 under chapter 4. No.
Stands crystallized in favor of an applicant proponent only after issuance of a mining permit in form L as per subsection 1 as per section 31 of the Assam Minor Mineral Concession Rules 1994 since repealed. Full stop. The process of granting mining leases, etc. has been made to undergo a competitive bidding process under the Assam Minor Mineral Concession Rules 2013, which replaced the Assam Minor Mineral Concession Rules 1994. As per Rule 79, Rule 79 of 2013 rules, AMMC rules, has provided for repeals and a saving clause, which reads as under 79. Para. No. No. I think this is the rule, right?
79, Your Honor. Of the
79
new rules.
New rules. Repeal and saving.
Would you want to would you want to see the rule?
I am looking at it. Any rights vested or accrued under the Assam Minor Mineral Concession Rules 1994 is saved by sub-rule 2 of Rule 79 of the AMMC Rules 2013. Under sub-rule 2, Rule 79. Under sub-rule 2 of Rule 79 of the AMMC Rules 2013. Right? on a pointed query to the learned counsel for the review petitioners, comma, we find that the situation recorded in the judgment and order dated 26/8/2019 to the effect that there was no subsisting formal order in terms of section Rule 31 of the Assam Minor Mineral Concession Rules 1994 since repeal, comma, has not changed as the review petitioners has not been able to place any such mining lease issued in favor of the review petitioners. In the absence of any vested or accrued right, in the absence of any right accrued or vested in favor of the review petitioners in respect of Baleswar, what is the name? Unit 2, Unit 2. Unit 2. Minor mineral unit number 2. Comma, neither at the time of the repetition nor at the time of the repeal nor at the time of the instant review petition, comma, we find no ground in our considered opinion, comma, the instant review petition is not merited. Post up in view of absence of such accrued or vested right in favor of the petitioners, comma, we find no necessity to consider all the other grounds asked in this writ petition on behalf of the writ petitions. Full stop. The review petition stands dismissed. No cause.
Deeply obliged. Deeply obliged.
None? Anything to?
Very happy Diwali, Honor.
Happy Diwali.